Hello everyone, my name is Atish Mathur and I'm incredibly happy to release the Magna Carta Foundation. What is the Magna Carta Foundation? The Magna Carta Foundation is a comprehensive course covering all the papers for GS Paper 2 for both the prelims and the mains exam. Now, the first chunk, the most diverse paper of GS Paper 2, which is Polity, is what I'm releasing today. The videos are approximately 100 hours and 90 hours of those videos are in a smartboard format. Approximately 10-15 hours are where I have sat down and have recorded those videos, and they pertain to specifically articles 19 to 21. I will redo them again because they're important for Mains 2024, and I will release them as sample lectures within a week. So I seek your forgiveness for the same. More importantly, you're able to also download the notes for all of the topics that we've discussed in this longish course on the Telegram channel. The link of it is in the description of this video. Thirdly, ये पिछले 5-6 महीने में कैसे हुआ? As some of you may know, that due to certain circumstances which were not mutually agreeable, I had to part ways with one of the leading educational startups of this country. But the students who were studying with me at that educational startup, both in an online and an offline capacity, the lectures had to be completed. So, unse hatne ke baad, I was immediately able to procure an arrangement where these lectures could be delivered to the students and they were given to them on my portal completely free of cost. Ye lectures, fourthly, are updated till about May 2024. And anything above and beyond this would be in the next iteration. Number 5. ये हम क्यों कर रहे हैं? As it is, as if you followed my Telegram channel, you would know that more than 10,000 students who had previously studied with me on that educational platform were able to access these courses, these lectures for completely no cost. So I thought might as well make these lectures available to anyone and everyone who'd like to study them in a singular manner. The next point is, this is a completely non-monetized video, which means इसमें आपको कहीं पे भी कोई ad break नहीं दिखेगा. आप जिस हिसाब से इसको अपने पेस पे पढ़ना चाहते हैं, पढ़ सकते हैं. And therefore, you will not have any interruptions to your learning process. इसमें से कुछ topics will be redone, and जैसे मैंने आपको starting में बताया था, as sample lectures for the mains Magna Carta, I have already been releasing a few. I'll release a few more in the course of this time. ये सिर्फ पॉलिटी है. कुछ समय में गवर्नेंस भी आएगा, सोशल जस्टिस भी आएगा और इंटरनेशनल रिलेशंस भी आएगा, और ऐसे ही यूट्यूब पे completely free आएगा. And lastly, and the most important reason why I would do this is, I always believe that education deep down under is a public good, and a public good must always be accessible. And इसके अलावा एक बहुत छोटा सा selfish reason भी है. वो reason ये है कि जब एक बार मेरे आज तक के सारे lectures आप सबके पास आ गए, इसके बाद का जो iteration होगा वो इससे बेहतर होना चाहिए. It is also a personal challenge for me to get better year after year, and that can only be possible so that I don't get complacent just because the lectures are there. तो इन reasons की वजह से I'm very proud, I'm very humbled, and I will always be in your debt for allowing me to be who I am. And I hope the Magna Carta Foundation Part 1 Polity does some benefit for you. Thank you and keep watching. This is a comprehensive course on paper 2 and related subjects. And through this comprehensive course, we're going to be covering all subjects of paper 2 and keeping paper 2 as the backbone, covering subjects related to paper 2. Now, this might sound a little surprising for you, but this is in fact the most effective and the most productive way to prepare for the civil services exam. Your GS paper 2 is comprising of 4 subjects: polity, governance, social issues, and international relations. And an advanced application of these four subjects can also be found in other papers in other forms. For instance, you would see social justice, which is correlated to social issues, which is in paper 1. You will see administrative ethics or governance ethics, which is a part of paper 4, which is an application of governance. You will also see internal security, which is best understood once neighborhood in international relations is covered, while internal security is in paper 3. So we've designed this course in such a manner that the most apt pedagogy of learning for the civil services is made available for you. Now what we're going to be doing is this. We're going to be covering the following things in this particular lecture. We will first be understanding the holy principles for preparing for the civil services. These are non-negotiable and these cannot be compromised with no matter what the circumstances might be. 2. The journey starts with the syllabus and ends with the syllabus. Often, we tend to ignore the most basic part of our preparation. In this lecture, we will very accurately and very intricately go through the syllabus and reorganize it, restructure it in a manner most comfortable and most efficient for the civil services exam. And because we call this the Magna Carta way to prepare, we call this foundation the Magna Carta course. So we have a certain way to deliver it. This is our own method and we will be speaking about it. We will be referring to you about how the syllabus is restructured, it is reorganized, our method of delivery, and in what manner would this be covered for you. And finally, I would be referring to you certain key indicators about the sources, what you should be going through, what you shouldn't be going through, what are the notes that you must read at all times, and what are the things that you can possibly ignore. Let's start. A government exam has to be prepared in a governmental way. कहते हैं एक सरकारी एग्जाम की तैयारी एक सरकारी तरीके से की जाती है. And the only two truths about the civil services exam, the true absolute truths, no matter what a book tells you, no matter what we as teachers tell you, no matter what the internet tells you, no matter what YouTube tells you, the only two things that are absolutely true, no matter what the circumstances might be, no matter what the trends might be, is the syllabus and previous year questions. Now, this is easier said than done. When we say the syllabus is important, when we say so, there are two basic questions we must answer at all given points of time. What is in the syllabus? What is directly in the syllabus? What is indirectly in the syllabus? What is directly not in the syllabus? What is indirectly not in the syllabus? The answer to these two questions, which have two further questions, which is what is in the syllabus directly, what is in the syllabus indirectly, what is not in the syllabus directly, what is not in the syllabus indirectly. This helps you prepare a circumference. This is your preparation boundary. And under no circumstances should you ever be violating this boundary or breaching this boundary. We have a singular one-point agenda to help you clear this exam. That's it. So the story starts and the story ends with the syllabus. and the best friend of the syllabus, specifically because of civil services syllabus being so vague at times, being so abstract at times, being so open-ended at times, are PYQs. PYQs help you answer the following questions. First, what was asked? Second, why was it asked? And an underlying factor, when was all of this asked? When this is cross-referenced with this, you're able to create what is called a priority matrix. You're able to create a simple list that for my attempt this year, I have read the syllabus, I've cross-referenced the PYQs, and therefore these are the things that I have to prepare more than anything else. This never disappoints. This will never let you down. So this is something that you must know at all points of time. Syllabus and PYQs. Allow me to show this to you, to demonstrate this to you with a simple example. In GS paper 2, in the polity section, there is something mentioned in the syllabus which says comparison of the Indian constitution scheme with that of other countries. Again, comparison of the Indian constitutional scheme with that of other countries. First things first, it doesn't say constitution, it says constitutional scheme, which means the larger themes, the larger ideas, the larger principles that have been enshrined in our constitution. Number one. Number two, it says other countries. We've got about 200 plus countries in the world. There is no way that you are supposed to know what the constitutional scheme of so many countries is. This is where, with the syllabus, the PYQ comes in. How do you analyze the PYQs? For every lecture, for every topic, we would be doing this in class, so that you also learn the art of deduction, the art of prioritization. Let's understand this. So from this part in the mains exam, and by the way, the mains pattern changed in the year 2013. That is when GS paper 2 was introduced. And from 2013 till 2017, not a single question was directly asked from this topic. So the students became complacent. They thought, oh, it's just there in the syllabus, we don't even have to prepare it. No. If it's in the syllabus, we've got to prepare it at all costs. Now from 2018 onwards, 18, 19, 20, 21 and 22, you will see every possible question every year, including 2023, in the exam. Now, what does this mean? Why are we speaking about it? And I've purposely kept 2023 out because I will do the prediction for you. See, in 2018, the question was India and US are two large democracies. Examine the basic tenets on the basis of which the two political systems are based. They're asking you the basic principles on the basis of which the democratic systems, the political systems of these two countries are based. This is effectively a question comparing a presidential form versus a parliamentary form with specific reference to India and the US. Now the question is, why did they ask you this in 2018? What happened in 2018? Now, very recently in 2017, we had a new president of India, which means there was a new political development, a major development that everybody would have known. This is not hidden in the newspapers anywhere. Everybody would have known sorry, that we've got a new president. So the mains questions asked you, compare India and US political systems. So that's number one. In 2019, the question was, what can France learn from the Indian Constitution's approach to secularism? They have very categorically mentioned the constitutional approach, the constitutional principle of secularism. But what happened in 2019? Why does the UPSC randomly and suddenly ask you a question in 2019? A very, very popular cathedral in France called the Notre Dame Cathedral was destroyed. It was set on fire. France for a long time has had a law which bans the hijab. They made amendments to that law and they proposed so that even mothers accompanying children for school trips can also not wear a hijab even if it is public. That caused another outrage. And several reports of several Jewish temples being attacked were also in the newspapers. So generally in 2019, France and religion were at some amount of conflict with each other. There was some amount of friction between religion and France. So in India, in the mains exam, we asked a question, the mains exam asked a question, what can France learn from India's constitutional approach, Indian constitution's approach to secularism? So again, there was a clear-cut current affairs context, like the previous one. Look at 2020. The judicial systems in India and the UK, now they're referring to judicial systems. And judicial systems are always going to be a part of the constitutional scheme of a country, because the constitution is supposed to provide limitations on the powers of the state. And one of the ways you do that is by establishing a system of courts which can check the powers of the government by invalidating unreasonable and arbitrary action. Anyway, the judicial systems in India and the UK seem to be, so they've spoken to you about UK now, seem to be converging as well as diverging in recent times, which means we are similar yet we are different in recent times. It is extremely interesting because UK has been a colonial ancestor for us, and a lot of our administrative systems have been imported from the UK because of their colonial rule. So the question was, highlight the key points of convergence and divergence between the two nations in terms of their judicial practices. The question was to theoretically cover a comparison of the judicial practices of the UK and India. So the larger question is, why would we do this? Why would the UPSC ask this? It's because in 2020, the Supreme Court of the UK, which by the way completed 10 years in 2020, and the UPSC loves these 5 years, 10 years, 15 years, 20 years, 25 years, basically anniversaries in an arithmetic progression of 5 years. They love these things. So the UK Supreme Court ruled on the prorogation, which basically means ending a session of a house. The Supreme Court of the UK gave a judgment on the prorogation issued by the British monarch with respect to a house. Now this is an extremely sensitive problem. It is a sensitive problem because the judiciary is getting into the internal practices of a legislative house. It is a massive question mark on separation of powers. And because it is a massive question mark on separation of powers, one can't help but wonder, is there a comparison there? And when we have imported a lot of our practices from there, there is a question comparing India and UK's judicial systems, right? There's always a context. In 2021, analyze the distinguishing features of the notion of equality in the constitutions of US and India. Why would they ask this? They've asked US again, and they've asked you to compare equality within the constitution, never beyond it. Why would they ask you this in 2021? They asked you this because of the Black Lives Matter movement, a movement because of racial discrimination against African Americans in the United States of America. So this was the reason. In 2022, critically examine the procedures through which the presidents, again the presidents of India and France are elected. Now, the procedures through which the presidents are elected would always be under the constitutional scheme, because presidents are head of states. They are first citizens of a country. They have a certain role to play in the limitation of powers of the government. So therefore, why would they ask you this in 2022? They asked you this because both India and the US, remember 2017 here, 5 years 2022, both India and France, had new presidents. So they asked us to compare the presidential processes, the presidential election processes of India and France in 2022. Now, similarly, you would see something to the tune of what is called 2023. Now let's see what happens. In 2023, in 2023, one second. In 2023, you will notice a very interesting question. In 2023, they asked you to compare parliamentary sovereignty between India and the UK, because the UK had a new prime minister, by the way, who was of Indian origin, and this new prime minister was without an election. It was an internal rechoice. So comparing parliamentary setups, a key difference between the UK parliamentary system and the Indian system. So therefore, the question becomes, if this is my setup, if this is something that I have to do, how do I prepare it for the exam? What do I do to get this part right? How do I know what parts to study and what parts to not? Look at the key deductions. The only 3 countries that they have asked, the only 3 countries, just give me a second, I'll set this up. Yes, the only 3 countries that they have asked are US, UK and France. These are the only 3 countries that they have asked from 2018 to 2023. And every time they have asked either of these countries, one of the following things has happened. Either a major event has happened in that country, or a major event has happened in India, or something that has happened commonly to that country and India. And all of these have happened at the most 6 to 8 months before the mains exam. Yes. Now see, how easy does it become? The year that you're writing the mains, you just have to track key developments of these three countries, check a cross reference to all of this, and then you know you only have this much to prepare for the mains of that specific year. This is the power of syllabus and PYQ. The most underestimated, the most underrated, but this is the actual power. There's nothing you can do to take it away. And once you've done this, there's no stopping you whatsoever. Clear on this? Now, let's move on. Syllabus and PYQ. Let's start with the syllabus. When you look at the syllabus of polity and governance in the mains exam, this is something that you will notice. First, when you look at it from a prelims perspective, your title is Indian Polity and Governance. And under this, they've mentioned the constitution, political system, Panchayati Raj, public policy, and rights issues. My simple question is, can I structure my preparation in this particular order? The answer is no. One, the constitution is a part of the larger study of polity. If the constitution includes Panchayati Raj, then why do I have to study the constitution separately? If rights originate within the constitution, then why do I have to study rights issues separately? If public policy is the largest study of problem solving by the government, would this not be a larger topic than all of it? So I cannot base my preparation on the basis of the syllabus that is being given to me in the prelims. This cannot be a 1A to 1E exercise as the prelims exam tells us to. However, let's try with the mains. Maybe the main syllabus is better structured. Maybe the main syllabus will give us some hope, some light. Now, this is your paper 2 syllabus. You will understand, undoubtedly it's an incredible syllabus, but is it arranged and organized in the most systematic manner that you can incrementally learn? We will show you. The answer is a staggering no. Let's see how. The first topic in the mains exam says Indian Constitution. Blanket, open-ended. And then it has the following things in it. Historical underpinnings. Okay. Historical context is a good way to start. Evolution. Started from X to Y. But evolution of the Constitution as a whole. Evolution of the Constitution as an entire document. That is not clear. Features. Does it make sense to study the features without actually studying the Constitution? Does it make sense to give a review of a car without driving a car? You first drive the car, then you give a review that these are the good things, these are the bad things. Even in your NCRTs, in fact, your class 11th NCRT, the Indian Constitution at Work, the last chapter of that NCRT is the philosophy of the Constitution. The first chapter is about the making of it. You never do features and philosophy before you've actually studied the Constitution. It'll be immature, it'll be premature. It's like me saying, oh, the Constitution is rigid and flexible, without even teaching you where all is it rigid and flexible. Once you know the processes, then you can automatically think, oh yes, it's rigid here, it's flexible here, it's a bit of both here. That's how you execute it. Then amendments. Do we do all amendments? Do we do the important ones? Do we do the landmark ones? Do we do the anniversaries of landmark ones? Do we do the recent ones? Absolutely no clarity. And without studying the Constitution as a whole in a certain process. Then they tell you significant provisions. Significant provisions again has the same question. What provision is significant? What is not? Is, for example, territory significant? Is citizenship significant enough? Are fundamental rights significant enough? None of that is clearly and categorically mentioned, right? And then basic structure. The most important doctrine, which is nothing but a legal principle, which is evolved by the courts through judgments. In this particular case, one of India's the most celebrated judgment of all time, one of the longest written judgments in South Asian history, called the Keswananda Bharti case versus State of Kerala. The Supreme Court gave the doctrine of basic structure. In very simple lines, it answers the following questions. 1. What in the Constitution can be changed? 2. Who can change it? And 3. To what extent can it be changed? The answers to these three questions is the basic structure doctrine. Without studying the provisions, studying the basic structure doctrine, which is essentially an outcome of certain rights and land related reforms, would be premature. But hey, the main syllabus in the first point asks you to practically study the entire Constitution. Look at point number 2. Functions and responsibilities of the Union and the states, which means now you have to study center state powers and center state relations, issues and challenges pertaining to the federal structure. Without knowing the center, without knowing the states, you've got to study center state relations. And then the devolution of powers and finances up to the local levels. Without studying the center, without studying the states, you've got to study something called local self-government. Without knowing who the president, prime minister, chief minister is, without knowing who the Supreme Court, High Court is, you've got to now study what the sarpanch does, what the mayor in an urban municipal corporation does. A little odd. And while you are struggling with this, point number 3 gives you another legal doctrine, which is separation of powers. You've essentially got 3 branches of government: the law-making branch, the branch that implements laws, and the branch that checks on the validity of laws, whether the laws are good enough or not. Sort of like the equivalent of the Hindu mythology of Brahma, Vishnu, and Mahesh, the creator, the executor, and the destroyer. So in Indian polity, we call them the legislature, the executive, and the judiciary. The legislature is the law-making branch, the executive is the execution branch, and the judiciary is the law-checking branch. Now, without studying what they are, how do they become what they are, what they do, you've got to now suddenly study why they need to be kept separate, why there needs to be a functional separation, a functional space between the legislature, the executive, and the judiciary. And while you are doing this, there is dispute redressal mechanisms and institutions in the third point itself, which means if there are conflicts of any kind, almost hinting to judiciary, they could also be referring to arbitration. This could also mean alternate dispute resolution. This could also mean tribunals. So you're effectively supposed to study out of court settlements without studying courts. So again, not a very wise way to structure our preparation. And then suddenly out of nowhere, the example that we were referring to, comparison of the Indian constitutional scheme with that of other countries. Comparison of the Indian constitutional scheme with that of other countries. Again, let's first study ours, then we will compare. Suddenly, by the fifth point, there is some sense that prevails. And what do you see now? Parliament and state legislatures very clearly. The structure, the functioning, the conduct of business, the powers and the privileges, and the issues arising out of these. Okay, makes sense, but perhaps a little too late. Then point number 6, the structure, the organization and the functioning. They have added both the branches together in the same syllabus, the executive and the judiciary. Then suddenly, ministries and departments of the government, and out of nowhere, organizations outside the government, pressure groups and former informal associations, and their role in polity. So while you are studying what a minister and a Supreme Court judge does, you then have to study, for example, what the Federal Chamber of Commerce does, what the Confederation of Indian Industry does, what is the impact that farmer organizations could have on policy making, all over the place. That's the point. And once you've done all of this in this order, you're supposed to then study the primary election law of our country. Elections in India, of course, they're at the apex level, governed by the Constitution, supported by a set of dedicated laws called the Representation of Peoples Act of 1950 and 51, which still continues to be in operation. And after all of this, in topics 9 and 10, you will now see bodies. So, appointment of various constitutional posts, which are constitutional bodies, their powers, their functions, their responsibilities, and then you will see statutory, regulatory, and various quasi-judicial bodies. There could be tens and hundreds of those in a country. Do we study them all? And regulatory bodies would have an interface with governance because they are governing. So, for example, do I study SEBI in polity? Do I study SEBI in corporate governance in governance? So now the lines between polity and governance tend to get a little blurred. Topics number 1 to 9 are effectively polity with a little bit of governance towards the end. Then you see topic number 10. Government policies and interventions for development in various sectors and issues arising out of their design and implementation. This means your entire governance syllabus effectively. This effectively is asking you study about everything that the government has done for development in every possible sector. Well, that is the definition of governance. So if you have this, why would you have anything else in the governance syllabus? But again, very open-ended. This is why PYQs become important. Only once we know for a vague topic what the UPSC has asked previously, can we sort of draw a boundary on it, a circumference on it, right? And then you have development processes and the development industry. NGOs, self-help groups, various groups and associations, donors, charities, institutional and other stakeholders. Every possible institution outside the government having an influence or a role to play in making the country better. If this is here, don't you think pressure groups is best studied here? They're also outside the government. They also influence polity. They would also want to make the country better in what they're doing. So you could see a little bit of a gap. Now, while 10 and 11 could be understood as effectively governance, look at what is in topic number 12 or line number 12. Welfare schemes for vulnerable sections of the population by the center and the states, and the performance of these schemes, the mechanisms, the laws, the institutions, the bodies constituted for the protection and the betterment of these vulnerable sections. Hold on a second. If I'm doing bodies here, was I not doing bodies in point number 9? So, the National Commission for Scheduled Castes, do I do this with fundamental rights? Do I do this as a separate body? Or do I do this in welfare schemes? I should not be doing this 3 different times. I should not be multiplying my original effort. I should be reading the same thing multiple number of times, but for once, and in a way that it covers everything. So if I'm doing caste, and caste is a vulnerable section, I should do it in a way that it handles polity, it handles governance, it handles social justice, all in one go. That's the efficient way to prepare. That's what I'm referring to. So for example, women are vulnerable sections. I will do the National Commission of Women along with women to make sure they're effectively executed, right? Then you have point number 30. Issues relating to the development and the management of social sector and services, suddenly relating to health, education and human resources. Now the interesting part with point number 12 and 13 is, for example, women is a vulnerable section, but role of women in women organizations are also in social issues of paper 1. When do we study them? How do we study them? Do we study them separately? Similarly, human resources will also have a little bit of an interface in paper 3. We've seen questions in paper 3 on primary health care as well. So do we do them there? Do we do the education sector of India as a whole in one go, in one place? That's the point. And then point number 14, issues relating to poverty and hunger. Again, in paper 1 and a little bit in terms of food security in paper 3. So do we do them together in one place or separately? Now, 10 and 11 seem to be governance. 12 and 13 and 14 seem to be social justice. You're then back to governance in points 15 and 16. Important aspects of governance, transparency and accountability. Then you have e-governance and the applications, models, successes, limitations and potential. Citizens Charter, transparency and accountability, institutional and other measures. This is effectively what is called good governance. Now when you're doing this, you then move to finally the role of civil services. But one second, isn't UPSC a constitutional body? So do I do UPSC there or do I do civil services as a whole here? So this becomes governance. This becomes 14. Points number 15 and 16 are also governance. 12, 13 and 14 is social justice, correlative to social issues. And then finally you have IR, India and its neighborhood, the relations of it. Then bilateral, regional and global groupings and agreements involving India or affecting India's interests. So when we do India-Bangladesh, wouldn't we not do bilateral relations between India and Bangladesh? So it has to be merged. Then effects of policies and politics of the developed and developing countries on India's interests, and unrelated as it might be, Indian diaspora. Unrelated as it might be, Indian diaspora. Clear? So Indian diaspora are people who have some connection on origin to India, settled outside India, who can be a very important stakeholder in determining better relations of India with that country and a sense of contribution to India's economic and other interests. And finally, important international institutions, agencies, and their structure and mandate. So it is a hot mess. This doesn't make sense. We've got to do this right. We've got to figure out how do we go about this. There are essentially 4 steps. First, segregate the syllabus. Second, cross-reference paper 2, keep paper 2 as the backbone and check if other parts of the syllabus can be done keeping paper 2 as the backbone. Why paper 2 as the backbone? Because paper 2 has polity. It has law, which is the start to everything. And once you have cross-referenced, then you organize it. That alright, this is where we put it together. And then you restructure it. So don't worry, for paper 2 and related areas, we've sorted this, and this is how it has to be executed in this specific manner. So let's start with step number 1. Segregate. This is your polity syllabus. This is your governance syllabus, right? As we were discussing when we set it up, when we were reading a point by point setup. So from Indian Constitution historical underpinnings to statutory, regulatory and various quasi-judicial bodies, from government policies and interventions to the role of civil services in a democracy. The point is, you will see that this has to be done together. This cannot be done separately in any manner because there is so much of a cross-reference. For instance, you will see, as we were speaking about it, pressure groups here. They should be done together here, right? The bodies will play a very important role in terms of good governance. So RTI, Central Information Commission, Lokpal, CBI, Enforcement Directorate. It is common to institutions of good governance. Always will be. Are we clear on this? Understood? That's the setup. And similarly, a common track between, say, UPSC and other bodies. So there is a need for you to study polity and governance seamlessly, in an integrated manner, in a graded manner, which covers both prelims and mains effectively. Okay? What we do for polity and governance, we also do for the rest of it. So let's go ahead and let's look at, say, the next parts of the syllabus. So let's understand it. So once we've understood segregation for polity and constitution as the syllabus and governance as the other one, let's look at social justice and IR. So you have 3 specific topics in the main syllabus which pertain to social justice, welfare schemes, issues relating to welfare schemes for the vulnerable sections, issues relating to the development and management of the social sector, and issues relating to poverty and hunger. And for IR, you've got 4 topics: neighborhood, bilateral, regional and global groupings, effects of policies on India, diaspora, and important international institutions. So we now know what in the syllabus belongs to what, right? So that's number 1. Step 1 is now complete. Step 2, let us cross-reference if there's something in paper 2 which correlates to something elsewhere. One of the strongest correlations is between governance and ethics in governance or administrative ethics in paper 4. For example, here it is referred to as the role of civil services in a democracy. This directly correlates to aptitude and foundational values of the civil service. So it actually makes sense to study civil services as one consolidated topic from a legal point of view, from a governance point of view, and from an ethics point of view. To put everything together in one bracket, because you're going to be covering it again and again. Similarly, it will have a degree of relevance in civil services values as well. Similarly, important aspects of governance, transparency, etc., UPSC has been very kind. You will see a direct correlation in point number 3 of governance and point number 3 of ethics in governance. In fact, you will see several terms which are actually repeated. For example, transparency here, and for example, transparency here. Property in governance, concept of public service, philosophical basis of governance and property, information and transparency, information sharing and transparency in government, right to information, codes of ethics, codes of conduct, citizens charter, work culture, quality of service delivery, utilization of public funds, challenges of corruption. All of these are effectively instruments of good governance. And a little bit of point number 3 will also have a correlation to civil services as well. So the point is, there is a very, very high degree of institutional overlap. In fact, when you're doing all of this, you would also be referring to the role of NGOs in good governance, the role of NGOs in making the country better. So there is a very high degree of the need to study governance and ethics in governance effectively together. It simply makes your life easier. Clear on this? Understood? Good. So once we've got this part right, we move to the next part. Social justice in paper 2 and social issues in paper 1 also have a very, very high degree of commonality. For example, when we are referring to vulnerable sections, we are referring to women, we are referring to children, we are referring to elderly, we are referring to disabled, we are referring to lower castes, let's say we are referring to minority rights, we are referring to, let us say, the LGBTQIA community, and so on and so forth. So, for example, women is a vulnerable section. Role of women and women's association would directly be related to vulnerable sections. Similarly, issues relating to poverty and hunger directly correlational to poverty and developmental issues and their applications to urbanization and problems, associated problems and their remedies. Now, once you've done this right, you would therefore understand that there is a need again to do all of this together. For example, they speak to you about, say, social empowerment. They speak to you about, say, globalization. Human resources has an impact on globalization, has an impact on social empowerment. If you do them together as a larger idea, it is easier, because social issues of empowerment, communalism, regionalism and secularism also give you a segue to internal security as well. At the end of the day, a couple of these vulnerable sections, such as caste, such as women, also are instruments of what is called social empowerment. So the idea is, pick each, finish them up. You start with understanding the society of India, understanding vulnerable sections, covering everything in vulnerable sections in one go. Take women, do the laws, do the institutions, do the schemes, do the social implications, do the remedies, everything together, and close it with the role of women organizations. all of this has to be done in a certain manner together. Makes your job efficient and easy. Similarly, when you look at cross-referencing IR and internal security, once you've done neighborhood relations, once you've done a little bit of society, you've done a little bit of social issues, a little bit of social justice, you are ready to take on the world. Once you've done neighborhood relations, when you've done policies and politics of developed countries, you are now ready to do security challenges. For example, Naxalism. For example, separatism, both in the north and the northeast. For example, regionalism. It is easier to study regionalism once you have a societal context, then you can do a security context. So the idea is half of IR leads to an easy entry into understanding internal security. Similarly, when you do important international institutions, you're also able to understand complex internal security problems such as terrorism, such as money laundering, and so on and so forth. So the idea here is do it well, do it together so that there is no unnecessarily advanced burden. So our step number 2 is very, very clear that we have cross-referenced it. Now comes the organization part. We keep paper 2 as the backbone, which has 4 components: polity, governance, social justice, and IR. Governance has strong correlations to ethics in governance. Social justice has strong correlations to social issues, and IR has strong correlations to internal security. So we do it in this order. Now that we've understood the organization part of it, we should look at restructuring it. So in the first instance, you study polity and the Constitution, followed with governance, followed with ethics in governance. But this syllabus has to be reordered. This has to be restructured. So how will we cover it for you? In this way. We'll divide the first module, polity and governance, which includes polity, constitution, governance, and ethics in governance, into a total of 13 themes. You first start with the introduction to law and policy. What is law? What is policy? Where does law come from? What are the sources of it? What are the legal systems? What is rule of law? What is constitutionalism? How many different kinds of constitutions exist? How can you classify them? What are the basic approaches to state systems? What is democracy? What is a parliamentary system? What is a presidential system? What is a direct democracy? What is an indirect democracy? Building your foundation right. Knowing India's legal history, knowing majorities, knowing their applications to lawmaking. This is theme number 1. Then you pick up how do you change the territory of India and how do you get to be a citizen of India. Then in theme number 3, preamble, rights, directive principles, and duties. Why? Because the exam asks questions on all of these together. For example, equality is in the preamble, rights, directive principles, and duties in some manner, form, or another. Now you've taken care of the people. Let's take care of the government. You start with the executive and you do it at a comparative level. President, governor, council of ministers at the center, council of ministers at the state. Then you pick up legislatures. Lok Sabha, Rajya Sabha, Assembly, Council. Lok Sabha, Assembly, Rajya Sabha, Council. You understand the electoral policy. You cover Representation of People's Act here itself. You cover electoral issues here itself. So your E is done, your L is done. Now you're going to do J, which is judiciary. Figuring out what does the courts and the legal system of India does. Supreme Court, High Court, lower courts, alternate dispute resolutions, arbitration, mediation, tribunals, legal reforms, judicial reforms, speedy justice, everything, legal aid, all of it comes under judiciary. So once you've done L, E and J, now is the time to do how can you keep them separate, and because these are the three sources of power, how do they keep a check on one another? So separation of powers and checks and balances. Now that you know what the center does, what the states do, now is the time to do center-state relations. Administrative, legislative, executive, emergency, everything is covered here. Types of federalism, formats of it, the evolution of it, everything. Once center and state L, E and J is done, you take it one level down. Local self-government, both the rural part of it and the urban part of it, and whatever miscellaneous provisions are left. Then you pick up the larger theme of civil services, the backbone to all of this. Everything, as I was discussing with you, from a legal angle, from a governance angle, from an ethics angle, values, everything put together in one place. Then bodies. Bodies which are not sectoral in nature. Constitutional bodies, statutory bodies, the ones that are not correlated anywhere else. So maybe an NCW, a National Commission for Scheduled Caste, a National Commission for Scheduled Tribe. All of those will have to be done within that sector. Then you pick up the development policy of the country. Everything. From LPG to direct benefits to Aadhaar to the JAM Trinity to public-private partnerships to production-link incentives to sectors which are not mentioned anywhere else. The sports sector, environmental governance, everything you finish up in development policy. And then you pick up developmental non-state actors, NGOs. This is by the government, this is beyond the government. So NGOs, self-help groups, other non-state actors, pressure groups, formal groups, informal groups, donors, charities, all other stakeholders here. And then the good way to do all of this. Responsibility, accountability, transparency, you would look at corruption as a theme, and this will cover both polity and ethics. RTI, CBI, Enforcement Directorate, Lokpal, Lok Ayog, everything from every anti-corruption body to other stakeholders, environmental governance, corporate governance, all of those in one specific place. How do you govern the sectors and the best way to regulate those sectors? So this becomes module number 1, has 13 themes. And once all of this is done, then you would be looking at a final theme that I don't write separately, but we refer to as the theme of closure. As the theme of closure. Analyzing the Constitution, analyzing its features, analyzing its impact, analyzing the philosophy of it all. That is how polity and governance has to be effectively concluded. Once we've done this, we then move to the next part, which is module 2, social justice and social issues put together. These are your topics. We divide them into 5 themes. Your social sectors: education, health, skill development, human resources, population policy, everything. Then social empowerment from social issues, vulnerable sections from social justice because they're correlated. Women, children, elderly, disabled, etc. in one go. From understanding society, from understanding the nature of it, the features of it, and so on and so forth. Then you move to poverty, hunger, and food security, which not only covers paper 2, paper 1, but also a little bit of food security and buffer stock measures, which is in paper 3. And once you're done with this, your closure, the features, the overall characteristics of the Indian society, like a closure theme. And once you've done this, the challenges to to Indian society, which will also help you understand internal security very, very well. So that's the process, that's the ecosystem. Once we've done this, once we're okay with this, we move to the fourth module, the third module and the fourth module. IR, decent enough, but keeping it incremental. Theme 1, understanding foreign policy, key terms, key players, key stakeholders, doing all countries and diaspora together. First do neighborhood, then do extended neighborhood, then do major powers, then do countries which are in news in this order, because all of these will have agreements which are or groupings which are bilateral, which are multilateral, and so on and so forth. And once we are done with this, you will then move to institutions, organizations, agreements, because you've already understood countries. And then you pick up themes in IR: environment, nuclear, cyber, maritime, and you cover all of these from a closure perspective. And once you're done with this, your internal security syllabus, which is linkages between development and extremism, role of external state and non-state actors, challenges to internal security, communication through networks, role of media, social media, cyber security, money laundering. Again, a big hot mess. Security challenges and their management in border areas, linkages with crime and terrorism, various security forces, agencies and their mandate, all of those. You restructure it in 4 simple ways. Introduction to national and internal security, the key terms, the key principles, the key actors, then non-state actors and their challenges. Theme-wise, left-wing extremism, Naxalism, Northeastern J&K separatism, terrorism. Then you pick up theme number 3, cyber security and the role of media, which takes care of topic number 3, and you close with the larger laws governing internal security, our security institutions, our regulatory institutions, and their agencies. So the fact of the matter is, this is how it's done. So we've got 4 modules. Module 1, Polity, Governance and Administrative Ethics. Module 2, Social Issues and Social Justice. Module 3, International Relations. Module 4, Internal Security. All of it is combined to make what is called the Magna Carta Foundation. Right? 1, 2, 3, and 4. Each theme gets divided into topics, then subtopics. We will ensure that most of it is in English, and of course you're going to be given PPTs and handwritten notes that I will be making, and of course we'll also be giving you our nationally renowned booklets, and anybody who's preparing for 24, 25 and beyond must definitely look at it. We'll keep updating it as and when there are particular developments. It becomes very easy. For example, let us say theme 1, topic 1, subtopic 4. If there is a major change, we will change this lecture entirely, or we will make an amendment to this lecture. It becomes very, very easy, like a plug and play device. So this is the larger ecosystem that we are playing with. So this is the foundation, and all of this is a part of a larger ecosystem called the Magna Carta ecosystem. The foundation course for pre and the mains, then you have a crash course for the pre, a crash course for the mains. You've all known me to do this for quite some time. We've always hit an accuracy ratio of at least 80% questions in the pre, and around 75 to 80% questions in the mains. It is an honor to teach you all through this platform. It's an honor to be associated with you. Shuni has been doing great work. Their vision for teaching what is right, doing the right thing, taking tough but very importantly good decisions, keeping the students at the center of it all is something that I most happily associate with, and together we bring you the very best to make sure that you prepare in the very best manner. So this is our foundation. Thank you so much. I'll see you with the Polity Lectures of Module 1 right away. Thank you. When we speak about laws, we start with the word law. Laws are legislative enactments. Law is a larger, incumbent, umbrella, overarching, universal term. Law is anything in any form, in any nature, that can indiscriminately be applied to human action. Law is something that affects us right from the day we are born to the day we are dead, and I think even after. But the idea is, law as a larger concept means something which could be applied to human action. When you look at it from a philosophical point of view, you would often hear of a term called jurisprudence. Jurisprudence is the knowledge of the law. A jurist is somebody who has the knowledge of the law. And in a few lectures from now, when we study the eligibility criteria for a Supreme Court judge, you will hear the word eminent jurist all over again. So basically, law is a larger idea, an idea which applies universally to the acts of us human beings. So if that is law, the larger idea of it, where does law come from? Now theoretically, there are three sources to the law: customs, judicial precedent, and legislation. Customs, as we understand it to be, is the oldest, because customs goes back generations, goes back to civilizations. In the modern world today, in the nation-state system today, in the democratic system today, customs are recognized through law, no doubt. And even today, in several parts of the world, in several parts of India, without the recognition of a law, in some societies, in some cultures, customs are given great precedent. But customs are the oldest and by far the most important source of law. For example, across the length and breadth of the country, Hindu marriages are performed in different ways. Given the fact that it's almost wedding season throughout the year, you would see Hindu marriages performed in different manners, in different methods, with different rituals. But the one thing common to almost all Hindu marriages in India are the first 7 steps around the circle of fire. And those first 7 steps around the circle of fire is called Saptpadi. And the Hindu Marriage Act, a law that governs Hindu marriages and divorces, recognizes Saptpadi as a valid custom, certifying that the marriage has happened as per the Hindu rituals and ceremonies. Very interesting. Similarly, you've got something called judicial precedent. Extremely important. Because ultimately, there will always be a conflict between the lawmaker and the law checker. The law checker is the judiciary. The lawmaker is the legislature. So judicial precedent actually comes from a Latin doctrine. To understand what Latin is to English is what Sanskrit is to Hindi. That's the simplest way one can understand Latin. It's an old language of the world. And law is one of the first things that the world evolved, so the language would also cater to that. So the word judicial precedent actually comes from the word stare decisis, or the doctrine of stare decisis. In one line, what does judicial precedent mean? Judicial precedent simply means the judgments of a higher court binding on a lower court. This means the courts have the power to govern lower courts, and the courts have the power to review the actions of the state. The state could include the legislature, and the state could include the executive. So it is actually out of judicial precedent that you would often hear the concept judicial review. So what does a court do when the court judicially reviews? The court validates or invalidates, the court interprets, or the court simply fills a gap. In what? In legislative action or executive action, depending on the country you're in, depending on how powerful and how extensive judicial review is. And judicial review is only possible because of judicial precedent. The judgment of a higher court binding on a lower court. Now, does this mean in India all judgments of all higher courts are binding on all lower courts? That's not the case. When we say higher courts in India, we refer to the Supreme Court and the High Courts. And when we say the lower court in India, we refer generally to all courts, district court and below. So when we say judgments of Supreme Courts are binding on High Courts, yes, judgments of High Courts are binding on their region, their state, the district courts of the state, yes. Is the entire judgment of the Supreme Court binding on all courts in the country? No. Because a judgment has two parts. One is called ratio decidendi, and second is called obiter dicta. Ratio decidendi and obiter dicta. Now these are Latin terms, they won't be asked in the prelims exam. But what does this mean? See, when you go to a court, when you file a case, the court formulates the core legal issues of the case. And the answers to those core legal issues, to those core legal questions, is ratio decidendi. This is binding. But as you know, while you're discussing some core legal issues, it can often happen that the court can give a remark on several other issues, on several other related circumstances. So in that sense, that is obiter dicta, and that does not have a binding value. For instance, let's take the case of right to privacy. The Supreme Court, in the right to privacy judgment called the Puttuswamy versus Union of India judgment, declared that the right to privacy is an implied right under Article 21 and also is correlated to Article 90. And it explained to you why right to privacy is a fundamental right. Because in the Puttuswamy judgment, one of the core issues were, is the right to privacy implied under Article 21? That's the ratio of the case. But in the same Puttuswamy judgment, the court also said bodily privacy is an instrument of privacy. So therefore, by extension, orientation is an instrument of bodily privacy. So if a person is somebody who's attracted to the same gender, identifies themselves as homosexuals, technically, if you are someone who is a homosexual, it is a matter of bodily privacy. It's a matter of decisional privacy and should come under the ambit of privacy. But was the Puttaswamy case about homosexuality? No. So that becomes obiter. So even though in the Puttaswamy case, the Supreme Court said very clearly that homosexuality is an instrument of privacy and privacy is a fundamental right under 21, it still does not mean privacy is to be decriminalized. It took the Navteej Singh Johar judgment just a few months later to confirm by the Supreme Court that yes, homosexuality should be decriminalized. That's the difference between ratio decidendi and obiter dicta. So this is also why you will never see a prelims question that says judgments of the Supreme Court are binding on lower courts, because A, the entire judgment is not, and B, all judgments of the Supreme Court are not binding on the High Court. The Supreme Court is a court of record. The Supreme Court is a constitutional court. Now, what is a court of record? We'll come to in a few lectures. But the Supreme Court is a constitutional court. The Supreme Court is a court that gives you interpretations. It's a court that validates or invalidates laws. It interprets laws. It fills the gap between laws, right? So the Supreme Court is therefore supposed to analyze the laws. But there's something in the Constitution that gives the Supreme Court the powers to inherently do justice. As a court of last resort, as a court of urgency, as a court of mercy. And sometimes the court issues specific orders under the powers to do inherent justice. The article is Article 142, we'll come to that later. Supreme Court orders under 142 are not binding on lower courts. This is also why you will never get a prelims question that says judgments of the Supreme Court are binding on lower courts, because that judgment, that statement that we've been hearing for all these years is technically incomplete, is technically partially right. This is the power of judicial precedent. And your third source is legislation, the law, the act, the legislative enactment. So, whether the legislature makes a law or the court declares something to be right, something to be wrong, interprets something as something, fills a gap in the legislation, you are effectively creating something that could indiscriminately be applied to human action. And that is the essence of sources of law. Based on these sources of law, all across the world, legal systems were developed. Now, these legal systems, in their pure forms, don't exist anywhere. But because they originated in a certain part of the world, you understand their core features. The Indian legal system is a combination of these multiple kinds of legal systems. You effectively have three major kinds: the common law legal system, the continental legal system, and the socialist legal system. Common law is not law that can be commonly applied. Common law is effectively something that originated from our colonial ancestors, the British. The British were a monarch, which means they had a king or a queen. The king or a queen was ordained by divinity. It was made to be understood that the king and the queen have been chosen by God to rule over people. That's the fundamental concept of monarchy. And therefore, you had certain regulatory systems around it. You had the commoners and you had the kings and queens. So the concept of common law comes from there. Now it also comes from England, and there is a little bit of an issue there, and that is England, we'll understand in some time, does not have a single written constitution, which means it does not have one book, one law that says the Constitution of England. It has multiple laws which contain equally important things that a single constitution would, but in 10 different laws. But there is no concentrated singular Constitution of England. So there are so many laws governing so many aspects. Some of those are as important and worthy to be in the Constitution. And England is also one of the oldest democracies in the world, and therefore would also have courts. So when we are discussing what are called legal systems, we are effectively answering a question as to, is the law made by the legislature more important, or is the judgment given by a court more important? Who has the final say? Who has the last laugh? Now in common law systems, the courts do, because you don't have a unified singular constitution. The courts will have the powers to review the law. So that is why the notions of judicial precedent is going to be extremely high when it comes to common law systems. Extremely high. Now this means a few things. This means the judgments are going to be technical, because they have the powers to review the law. This also means that judges will necessarily come from legal backgrounds. They are necessarily the ones who will be trained in the law. No doubt, your legislations are important, but the legislations can be substantively reviewed by the courts. That's the concept of common law. And because the Britishers had it, the colonies of the Britishers had it. So most colonies in the world which have been British colonies have had some form of a common law system. We are one. Australia, New Zealand, Canada, we're all common law systems. That's the general understanding. In India, we do have the powers of judicial review. In India, the courts can review legislation. In fact, in India, to be a Supreme Court or a High Court judge, you have to be a practicing lawyer for 10 years at the High Court. In fact, when our state governments are conducting their state judicial services exams, you have to be a law graduate to write those exams. We are very clear on this. You've got to be a lawyer to be a judge. That is something that we've taken from common law, right? Now, there's something called continental law. It's also generally understood to be the liberal legal system. Now, the continental legal system originated in the European part of the world. It is also often called the Romano-Germanic system. There are multiple variations of it. You'll have a continental Scandinavian system, a continental Portugal system, a continental German system, a continental Roman system. The idea is that it is originated by the product of academics, thinkers, scholars, professors at universities. They came up with these ideas of continental legal system which were adopted by the governments of their countries. It is exactly the other side of common law, because common law is very watertight, it's very rigid, it's very formal, and it gives the judiciary a sincere amount of power. And judiciary is by the nature of it not democratic. The judges in most parts of the world are appointed. In democracies, the power must lie with the lawmakers. So while the common law system gives enough power to the law checkers, gives decent power to the lawmakers, the continental legal system is very clear. The continental legal system says the lawmakers are paramount. The lawmakers are going to have the final say, the final laugh, the final hooray. So what generally happens in a continental legal system is the courts have negligible powers of judicial review. The concept of judicial precedent is extremely diluted. For example, France. The Supreme Court of France, if I remember correctly, is called the Court de Session. The judgments of the Supreme Court of France are not binding on lower courts. In fact, judgments of higher courts of continental systems are only binding on the people before the court, on the parties who've approached the court, nothing else. So this means the courts have a very simple, straight-jacketed responsibility, and that is read the law, interpret it, or even better, read the law, apply it. Don't interpret it, don't analyze it, you can't validate it, you can't fill any gaps. If there's any interpretation, any validation, any updation, any filling the gaps, leave it to the parliamentarians, leave it to the academic scholars. They will do it for you. Your job as a judge is to apply the law, which means, do you really need to be a lawyer to apply the law? Which is why in continental legal systems, yes, you have law schools, yes, you have legal education, but it's not necessary for you to be a judge, for you to be a lawyer, for you to be a judge. You can be a scientist, an engineer, you could be a doctor, and you could still be a judge, because you're simply applying the law. You're not interpreting it. And that's the functional difference. Now, what generally happens is, in a common law system, when the courts have the power to interpret the law, you would often see the caricature of the Lady of Justice blindfolded, right? Very recently, about 2-3 days ago, when the Uttarakhand government has released their draft of the Uniform Civil Code, symbolically they have removed the blindfold from the Lady Justice. But traditionally, the Lady of Justice has a blindfold, right? This is because in common law systems, the courts have to play an adversarial role. The judges do not intervene in the process. They give a judgment on the basis of what is presented to them. That is why in India we say the truth is what you can prove in a court of law. If you can't prove it in a court of law, it's not the truth. Everybody would know what the real truth is, but the judge will not apply her mind. Simply decide on what is presented before the judge. This is called the adversarial system. There will always be lawyer A versus lawyer B, party A versus party B, and the judge will simply take it all in. That's not the case with continental law. In continental law, the judges play an inquisitorial role. The judges are a part of the case. Everybody is working together to find the truth. Take the case of South Korea. South Korea has sort of a continental legal system. So let us say it's an environmental case in South Korea where you're trying to decide whether an industrial development is going to hamper the environmental balance of a region. The judge, both the lawyers, both the parties can go to the site, investigate, come back and decide. That is what is called the continental legal system. And thirdly, and this is the interesting part, India has a little bit of continental legal system in its blood. You may have heard of several judicial commissions. You would have heard of the Nanavati Commission. You would have heard of the Godhra Commission. You would have heard of the Lingaraj Commission. You would have heard of the Justice Verma Commission. In fact, very recently in the Pegasus case, the Supreme Court appointed a committee wherein if you think your phone has been hacked by Pegasus, come to the Supreme Court committee comprising of Supreme Court judges and they will look into the matter. Are we not? We are a little bit continental in our own right. We also have the concept of tribunals today. In tribunals, you have judges and you also have ex-bureaucrats who are also judges. Ex-bureaucrats are not necessarily trained in the law, but they are officiating as judges at tribunals. So India has a little bit of what is called a continental legal system. And when the world moved towards the Marxist revolution, the socialist legal system was born. The socialist legal system is based on the principles of socialism. Socialism is where the government's role in the lives of the people to make the lives of the people better is unquestionable. The government is the only reliable permanent agent of development. The government will own, operate and manage public resources. So anything that challenges the government, including judicial precedent, would be given lesser importance. There'll be a public law, there'll be a constitution. Governmental laws are above and beyond. We have a little bit of that in India also. World over, Russia has this for some time. China has had this for quite some time. Now I know China today is largely identified as a communist regime than a socialist one, but China has had its socialist history roots back in the day. But in India, you have something very similar. In our constitution, you have directive principles, and we will discuss this in fundamental rights. 2 directive principles are stronger than 2 fundamental rights even today. Directive principles under Article 39B and 39C are stronger than Articles 14 and 19. So basically, if the government wants to implement something to prevent concentration of wealth or to promote equal distribution of resources, and the only problem that you have with that is 14 and 19, equality and expression, too bad, nothing doing. So yes, we have a little bit of a socialist legal system in our blood, which is what I said at the beginning. We are not a purist. Nobody in the world is a purist. The same way, no country is purely capitalist, socialist or communist. No legal system in the world is purely common law, continental law or socialist. No doubt, India has the greatest influence of common law, maybe 60% of it, maybe 70% of it, a little bit of 20% of continental law, and the remainder 10%. So that's how our legal systems are bifurcated. On the international front, because the world today is a more interconnected space. The world today is a far more open space. There is a need for intergovernmental coordination. So legal systems in the world have been developed. The finest example of an international legal system that I can give you is the European Union. The European Union is a political union, it's an economic union, it's a customary union. For example, you have something called the European Union. The European Union is a political union. It has the European Parliament, the European Charter for Human Rights, the European Court of Human Rights. All of this is binding on members of the European Union. There's also something in Europe, a subset of it, called the European Economic Area. So countries who are a member of the European Economic Area will have free movement of material across borders. No tax, no customs, nothing. And you also have the Eurozone, a monetary union, where you have a singular currency as that of a euro. Now the idea is, the principle of the international legal system is the principle of foreign policy. And the principle of foreign policy is national interest and sovereignty. You cannot force the international legal system upon anyone. The countries willingly, on their own, have to accept it, which is why you have two concepts related to international documents. You're either ratified to it or you're a signatory to it. If you have been a signatory to an international document, that means you don't have to implement it. You are not bound by it. But if you've ratified an international document, then you're going to come back home and make whatever necessary changes you have to implement it. You have decided as a country whether you want to be a signatory to a document or do you want to ratify a document. For example, India ratified the UN Convention on Prevention of Drugs in Sports. So just a year or so ago, we passed the Anti-Doping Act. We created a national anti-doping agency because we are ratified to it. We are also, I think, we've also ratified the UN Convention on against corruption. So a few years ago, we made changes to our corruption law, and not only is it illegal to accept a bribe, it is also illegal to offer a bribe, so that you can cut the demand and the supply of corruption alike. So this is how the international legal system works. It works on the principle of ratification or being a signatory. Of course, there are many layers to this, but for the prelims exam, this much information is good enough. And that finishes my first topic. And from the first topic, we shall now move to the second topic, which is majorities. Majorities are about the law of averages. The law of averages is what defines a democracy. And what is the most clear instrument of a democracy? The laws that are made in a democracy. So, before we start understanding majorities, let us connect topic 1 with topic 2 by understanding very simply and very conceptually the types of laws. Now, there are largely two kinds of laws: international laws and national laws. National laws are also called municipal laws. Don't ever confuse municipal laws with municipality laws. A municipal law is an international term for a national law. Now, let's talk about international laws. There are two kinds: public international law and private international law. Now, public international law is that branch of law that largely governs countries, relations between countries, aspects of countries, issues between governments of countries. So, for example, your Geneva Conventions are examples of international laws. Your Vienna Conventions are examples of international laws. Your Paris Climate Action Change Treaties are examples of international laws which are public in nature. Now, in the ecosystem of public international laws, treaties, documents, covenants, conventions, they all mean the same thing. They're as good as the people who sign them. So as I said, public international law is a law that governs the conduct between two countries, conduct between many countries together. It regulates the actions of countries based on certain issues globally. So for example, you can have an international document called the International Covenant on Civil and Political Rights. You can have a document called the International Covenant on Economic, Social and Cultural Rights. Now, countries who ratify these documents would want to uphold the values of these documents back home within their legal systems. Private international law, on the other hand, is a law that governs the conduct of private individuals, but in two different countries of the world. So, for example, a Sri Lankan businessman is exporting to an Indian businessman who's going to repackage, add some value, and then export it to a Nepali businessman. This is an example of private international law. Now, private international law obviously is not in our curriculum. Public international law, in terms of major organizations, in terms of major documents which are in use, I would anyways be referring to them in my final lab document. What concerns us are national laws. Now, there are many ways to classify national laws, and each law could be a combination of these identities. The first of which is who is the subject of the law, who's the target audience of the law, who is the law trying to govern. On the basis of that, you've got two kinds of national law, public law or private law. Public national law is effectively that law which governs the government or governs the government and the citizens. The finest example of a public national law could be the very Constitution of India. It governs the government and also gives the citizens certain rights against the government. Another example of public national law could be, say, the civil services rules, the laws that govern the conduct of civil services. The civil services is the government. So, public national law. Most laws are public national laws, and there are a very few set of laws which are called private laws or personal laws. There are three basic aspirations of a person's personal life: marriage, adoption, and inheritance. Laws that govern marriage, adoption, and inheritance are generally called personal laws. And these laws, as we've discussed just a few minutes ago, are greatly inspired from customs. So the Hindu Marriage Act, the Muslim Marriage Act, the Special Marriage Act, these are all called personal laws. And the idea of having a singular personal law covering all aspects of marriage, adoption, and inheritance of all religions in one single law, the concept of it is called the Uniform Civil Code. So one way to do this is by the subject of it. The second is the level of which the law has been made. If the parliament has made a law, then it is called a central law or a parliamentary law or a union law. The law is ordinarily applicable to the entire territory of India. There can be a few exceptions here or there. Back in the day, because of Article 370, that used to be a standard exception. But nowadays, ordinarily, parliamentary laws are applicable throughout the length and the breadth of this country. If the law is being made by the state legislatures or by the legislatures of a union territory, if they choose to have one or if they can have one, it's called a state law or a regional law or a provincial law. That law is only applicable within the territory of the state. And now we live in the era of local self-governments. And through the 73rd and the 74th Amendment, through the 11th and the 12th schedules to the Constitution, our panchayats and our municipalities on a state-by-state basis, on a differentiated mechanism, also have the powers to make those kind of laws. So for example, a law made by the Gram Panchayat of a specific village in a specific state would be applicable to the village area of that village of that state. Now, local laws are not particularly to be worried about as far as our exam is concerned, but yes, there are local laws. They're often also called grassroots laws. The third kind of law is laws classified on the basis of subject matter. What does the law contain? Generally, a law is either a civil law or a criminal law. Now, as you would know, a criminal law is effectively something that is dealing with crimes. And what happens is you either go to jail or you pay a fine or you do both of those things, or somebody may be sentenced to death penalty. A civil law is a law which tries to be status quoist in nature. It tries to rectify civil wrongs. It tries to bring back things to the way they were. So you may have to pay maybe a compensation. You may have to return something that you may have taken of somebody. So property laws are generally civil laws. Matrimonial laws are civil laws. Contract laws are civil laws. The company law is a civil law. The new criminal code, the new penal code is a criminal law. The Juvenile Justice Act is a criminal law. The Protection of Civil Rights Act, which specifically criminalizes untouchability, is a criminal law. In fact, very interestingly, it's the Protection of Civil Rights Act of 1955, which also, if you are found guilty under, would ban you from elections for 6 years after you've been released from jail on a conviction under the Protection of Civil Rights Act of 1955. So basically, what you have is a civil law and a criminal law. Apart from the fact that in criminal law you go to jail and the civil law you don't, there's a finer difference. The difference is criminal law is an exact law. For you to be found guilty, there has to be no reasonable doubt that you are indeed guilty. But when it comes to civil law is a probability law. It's a proximate law. For you to be found liable to pay compensation, it sort of seems like the most likely thing to do. It may not be exact, it may not be precise, but it is most probably right. Then you have laws based on depth. A general law or a specific law. A general law is a law which covers everything about a specific branch in one place. For example, the new criminal law, the new criminal code, the new penal code. It has a brand new list of crimes, a brand new list of punishments. Most of them have been carried forward from the older IPC, but it is a collection, it's a database of crimes and punishments. Whereas the Juvenile Justice Act very specifically deals with child criminals. The Protection of Children Against Sexual Offences, POXCO, is a law specifically dealing with sexual crimes against children. So that's the difference between general law and specific law. The general understanding is specific law will override the general law in case there is a conflict. And you finally have the purpose of the law. Substantive and procedural. A substantive law is a law which says X is right, Y is wrong. A procedural law says, okay, something has happened to you which is wrong, maybe Y has happened to you, how do we go about making Y right? What is the procedure? For example, let's say the new criminal law is a substantive law. The new procedural law is a procedure law. The new criminal procedure law is a procedural law. So for example, let us say theft. Theft is a crime, is substantive law. What police station to go to, what kind of a complaint to be filed, what kind of an FIR could be possibly registered is all a matter of procedure. So that's the difference. So for example, let's take the case of the new criminal law. The new criminal law is a public law, it's a central law, it's a criminal law, it's a general law, and it is a substantive law. And this is how laws are bifurcated. Now, if there are laws, laws can be changed, laws can be added, laws can be removed, laws can be amended. Because at the end of the day, democracy is about majorities. And therefore, we must understand majorities. Majorities is the celebration of democracy. It is the mathematics of democracy. It's the science to democracy. What is the number of yeses you need for something to happen? Majorities are applied in two ways. First, to laws, and second, to legislative procedures. What we are primarily concerned in the first lecture is application of majorities to laws. I'll give some reference to legislative procedures, and there are several additional special cases such as emergency, such as state resolutions, and so on and so forth. We'll come to that in a while. But generally, majorities are things that you need to do to pass laws or to pass certain procedures. Procedures to make certain things happen. Now, there are essentially two ways to look at it. One, majorities that require more than half of something. And two, majorities that require more than 2/3 of something. The difference is, if you require more than 2/3 of something, what you require is a 2/3 majority. And generally, things that will require more than 2/3 of something will generally have a little bit of a federal impact, will have a little bit of a center state impact. Now therefore, let's understand this. When we look at more than half of something, there are essentially three majorities that we are referring to: absolute majority, effective majority, and simple majority. Let's start with the highest, because that's how the graph gets to be plotted. Now, absolute majority. Absolute majority is more than half of the total strength of the temple of democracy, which is the legislature, the specific legislative house. More than half of the total strength. The purpose of the absolute majority is to establish a majority in a certain house. Now, India is a parliamentary democracy. At the union level, we have a bicameral setup. So the Lok Sabha is the lower house. All states in India have one lower house. Some states in India also have a second house, like the center. But the purpose of the absolute majority is to establish majority at the lower house. So therefore, absolute majority is only used in lower houses. So what are our lower houses? The Lok Sabha, the legislative assemblies of the states, and those union territories which also have legislative assemblies. In India, we're supposed to have three: Delhi, Pondicherry, and J&K. And out of the three, we have two functioning legislative assemblies with Delhi and Puducherry. So that is effectively what is called absolute majority. More than half of the total strength used to establish majority. This half could be with a single party, it could be a bunch of parties put together. As long as you have more than half of the total number of seats in that house, you have majority in that local house. So for example, the Lok Sabha. Let's say the Lok Sabha has about 543 seats. These 543 seats come from 543 constituencies across the country. Whichever party or a collection of parties gets more than half of these 543 seats, that's about 273 seats. This is your magic number at the Lok Sabha. As long as you can do that, you have what is called absolute majority. That's the purpose and nothing else. Absolute majority is used to establish majority so that you can decide who your ministers are going to be. Then you have effective majority. Now, a simple way to understand this is, for example, there is a classroom. There are some decisions that can be taken by everybody who's enrolled in a course. There are some decisions that have to be taken by everybody enrolled in the course on the first day. That's like absolute majority. There are some decisions that will have to be taken by only those students who are currently enrolled in the course. Some of you may have withdrawn. So that would mean effective majority. And some day-to-day decisions could be taken by the students who are currently present in the class and wish to take a decision, that is present and voting, or simple majority. I'll come to that. So, effective majority. Effective majority is more than half of the effective strength. What is the effective strength of the house? The true strength of the house. A strength that is valid. That means the total strength minus the number of members who have either died, have been disqualified, or have been resigned. So total strength minus DDR gives you effective strength. So more than half of the effective strength is called effective majority. This effective majority has one single purpose: to remove the class monitors of the house, the presiding officers, and therefore it is applicable to all houses. Lok Sabha and Rajya Sabha at the center, legislative assemblies of all the states, legislative assemblies of union territories, and also second houses of the states that have second houses, the legislative councils. And you have presiding officers. You've got speakers and deputy speakers in the lower houses. You've got chairpersons and vice chairpersons in the upper houses. There is just one minor special category, and that is the chairperson of the Rajya Sabha. The chairperson of the Rajya Sabha is the vice president. The vice president is ex officio the chairperson of the Rajya Sabha, which means whoever is the vice president is also the chairperson. So when you're removing the chairperson of the Rajya Sabha, you are removing the vice president, which is why in the removal of the vice president, you will have effective majority in the Rajya Sabha, and after the Rajya Sabha has done its job, you would have what is called simple majority in the Lok Sabha to confirm the vice presidential removal. This is effective majority. Once we've understood effective majority, we then understand the most widely used majority, which is simple majority. More than half of the number of people in a house who are present and are wanting to vote. This could be a yes vote, it could be a no vote, but they're wanting to vote. So more than half present and voting means more than half of the people who are present and have voted yes in your favor. Now, you would use this in all houses: Lok Sabha, Rajya Sabha, assemblies, legislative councils, legislative assemblies of union territories, everywhere. The idea is you will use simple majority to add amend or delete any law which is not the Constitution. So any law in the country, a central law, a state law, which is not the Constitution, you will simply use simple majority. Any law. The new criminal law, simple majority. Juvenile justice, simple majority. The new telecom bill, simple majority. The, let us say, the Protection of Civil Rights Act, simple majority. The anti-doping law, simple majority. Any law which is not the Constitution will be changed through a simple majority. And you will also use this to change some parts of the Constitution. Those parts will explicitly mention that these are not branded constitutional amendments under 368. For those kinds, you will use simple majority. And because majorities are also about procedures, you will see simple majorities to be largely used for parliamentary motion. So technically, anything which has the word motion after it, no confidence motion, censure motion, no confidence motion, calling attention motion, they will all be used using simple majority, right? So all of these are in the more than half bracket. Then you have the federal majority, more than 2/3, special 1, 2, 3 and 4 in ascending order of strength. This was in descending order. So special majority 1. Special majority 1 just requires more than 2/3 of present and voting, just a notch higher than simple majority. And I'd like to generally and colloquially call it as a resolution majority. You use special majority 1 only and only in 2 cases. It is to authorize. When the Rajya Sabha has to authorize the parliament, which includes itself, to create a new All India service, you would require special majority 1. Similarly, if the state legislative assemblies want a legislative council, they want to tell the parliament that they want a legislative council, in that scenario, they will pass a resolution saying, hey, we want a legislative council. We are dead sure about it. None of this means that the council has been created or a new All India service has been added. It simply means that once the Rajya Sabha has passed a resolution, now the parliament can start the process of making a law on All India services. If the parliament wants, they can make a law creating a state legislative council for a specific state. That is generally what is meant by it. Now comes the most misunderstood majority, which is special majority 2. Special majority 2 is essentially a dual majority. Now what happens here is, you will ask the same question to the House and ask them to vote twice. One, and the second time to reconfirm. So are you sure? Are you really sure? Now how does this work? When you ask the House for the first time, they need to say yes with more than half of the total strength, which means you already have a gigantic approval. Now just to be doubly sure, a little bit of a nudge, you ask the same House the same thing again, and therein they have to answer by saying more than 2/3 of present and voting. Theoretically, this could also mean that the present and voting strength could be similar to a total strength, which is a rare scenario but is possible. But in special majority 2, you ask the question twice. The House votes twice. There have been several instances when the House has voted positively once, asked the same thing again, and they voted not with the same numbers the second time. In fact, before the anti-defection law, which was inserted through the 52nd Amendment of 1985, was finally passed. There were previous attempts that were made in the late 70s, and they were not passed because you could not get it right the second time. Now, what is interesting about special majority 2 is it is only and only a parliamentary majority, which means only the Lok Sabha and the Rajya Sabha get to use this. The Lok Sabha votes twice and the Rajya Sabha votes twice. The two most popular ways to use special majority 2, because you're using a heavy majority, is to remove Supreme Court, High Court judges and to remove the Comptroller and the Auditor General, a very unique constitutional body which comes the closest to performing what is called an internal checks and balance function. That is why it is given the same kind of equivalence in terms of removal as a Supreme Court, High Court judge, and also a type of branded constitutional amendments under Article 368. We'll talk more about this just in a few minutes. So this is special majority 2. In terms of things within the Constitution, it is one of the most widely used. So this is like the simple majority for constitutional changes. Simple majority is the simple majority for out of constitutional changes. So bear that in mind. And then we finally have special majority 3. Now special majority 3 is a multi-layered majority. It is here where both the center and the states participate. Special majority 3 is basically special majority 2 plus something else. So what happens is, it starts at the Union Parliament, either the Lok Sabha or the Rajya Sabha, and you do exactly the same thing as special majority 2, which is you ask them once, more than half of the total strength. You ask them again, more than 2/3 of present and voting. Once both the houses have done this, you directly send this to all state legislatures and the legislatures of union territory. And amongst all, if half of them pass the same thing with simple majority, what you have is collectively state ratification. So this is constitutional changes through state ratification. So special majority 3 is special majority 2 plus state ratification. Half of the total number of regional legislatures have passed the same thing, but using a simpler majority called simple majority. So special majority 3, the upper part of it is only used by the Lok Sabha and the Rajya Sabha, and the state part of it is by the regional legislatures. And it is only and only used for one thing, which is constitutional amendments under Article 368, a very special type. The amendments to the Constitution under 368 using special majority 3, and the amendments to the Constitution under 368 using special majority 2 are two completely different types of amendments to two completely different kinds of provisions in the Constitution. And finally, you've got special majority 4. Special majority 4 is nothing but the toughest majority that exists in the Constitution today. It is more than 2/3 of the total strength of that house. Now what happens here is, you use it only for the Lok Sabha and the Rajya Sabha, nowhere else. And while you do this, you only and only use it for one simple purpose, which is the impeachment of the president. That is all that you would ever use these majorities for. Are we okay with this? Do we understand this? This is how you use your majorities. The toughest in terms of numbers, special majority 4. The toughest in terms of the sheer number of agencies involved is special majority 3. As you can see, special 1, 2, 3 and 4, all of them in some manner, form or another are federal implications. When you're creating a new All India service, which is basically a civil service recruited by the center, removed by the center, but they work at the states, has a federal implication. The states wanting a second chamber, a federal implication. Supreme Courts, our judgments are binding on the entire country. They listen to center-state disputes. High courts are the highest judicial organs in a state. The CAG reviews central action and state action. So there is a federal implication. These constitutional amendments have a very direct federal application, and the president, who has the powers to impose emergencies on states, is a federal implication, which is why these special majorities have a federal idea to them. And by the way, all of these terms, absolute, effective, simple, special 1, 2, 3 and 4, these terms are nowhere mentioned in the Constitution. These are commonly used terms. They are used for general reference. So in the prelims exam, you will always get full descriptions. You will always get full explanations. That, for example, the Supreme Court of India, a judge of the Supreme Court of India is removed by a majority of more than half of the total strength and a majority of more than 2/3 of present and voting, or not less than 2/3 of present and voting. That's generally how they write it. So this explains to you how our majorities run. Now we understood majorities are deeply used to make laws, which makes me move to the third topic. What are the different laws and what kind of majorities are required to make changes to those laws? We've studied types of laws, we studied types of majorities. Let us now merge them together and understand the application of majorities to lawmaking as topic number 3. The next topic, legislative changes. Applying majorities to lawmaking. Let's understand this. Our country has a hierarchy of laws. The Constitution above every other law. So basically, when we talk about legislative changes, we refer to changes made to the Constitution and changes made to any other law. Let's talk about the Constitution and any format of changes. The first and the most important question is, can you replace the Constitution? Can you delete the entire Constitution? The answer to that is no, you cannot. Article 368 gives the power to the Parliament to amend the Constitution. And amendment is understood to be a change, not the replacement of the entire law. So the Constitution of India cannot be replaced with a new one entirely. You could do it provision by provision, is a different story. But can you replace the entire Constitution of India Act 1950 with the new Constitution of India Act 2024? You cannot. Can you delete the Constitution and say, we're not going to have any Constitution whatsoever? No. Because, not only because of 368, but the Supreme Court has also devised the doctrine of basic structure. So what can you do to the Constitution? You can add a provision, remove a provision, or change a provision, but a specific provision. And you can do so in 3 ways. Either using special majority 3, or using special majority 2, or using a simple majority. What's the difference? Special majority 3 is used specifically in those cases which are listed in black and white explicitly under Article 368. Clearly, as clear as day. Simple majority is to be used to change those articles in the Constitution where under those articles it is written that changes to these articles have nothing to do with Article 368. It would be clearly mentioned. And special majority 2 is where neither of the two things apply. Neither are those articles specially mentioned under 368, nor under those articles in black and white is it written that they have nothing to do with 368. And that's the general difference. The conceptual difference is special majority 3 is something which requires a federal implication. A simple majority constitutional amendment is something which showcases center stronger than the states, and everything else in the middle is a special 2 majority. Now, special majority 3 will have direct federal impact and indirect federal impact. Let's understand this. All of these are clearly categorically mentioned under Article 368, one of the golden articles of our Constitution. There are 10 things that are mentioned. What are directly federal are, for example, Article 54 and 55, which specifically deal with presidential elections. So any change to 54, any change to 55 will automatically require special majority 2. Similarly, Article 73 and 162, the executive powers of the union and the states, which is correlative to their legislative power. Article 279A, which is the creation of the GST Council. Mind you, the GST Constitutional Amendment Act, the 101st Amendment, which introduced the concept of GST, did not require special majority 3 because the center anyways had the powers to do so. But the GST Council Act changes the role of the center and the states and the powers that they have to determine GST rates. So this would require special 3, but the 101st Amendment would require special 2. Chapter 1, Part 11, the legislative relations of the union and the states, correlated to the 7th schedule. So you move anything from concurrent to state, state to concurrent, union to state, state to union. Any changes to the union list, the state list and the concurrent list would attract what is called special majority 3. And if you're changing the number of seats that the states would have to the Rajya Sabha, which is a federal chamber, a representative of state will, and the reason that you're changing those seats have nothing to do with territorial causes. For example, if you bifurcated Andhra Pradesh into Andhra Pradesh and Telangana, because of which Andhra Pradesh's Rajya Sabha seats share goes down and you have to allocate it to Telangana, this will not require special majority 3. In fact, this will require a simple majority as categorically mentioned under Article 4. But if you're changing the way Rajya Sabha elections are conducted, if you're changing the total seat share, it will require special majority 3. A simple example of special majority 2 is changes to Part 3. And under changes to Part 3, please understand this as clearly as you could. Under changes, for example, any fundamental right that is changed. For example, you added Article 21A, the right to education. It would require special majority 2. For example, you added EWS provisions under the 103rd Constitutional Amendment of 2019. Special majority 2. You made changes to 15 and Article 16 of the Constitution. And then you finally have a simple majority. Now with simple majority, the article categorically mentions under it that a change to this article will not require what is called a constitutional amendment under 368. In fact, you will not even use the word constitutional amendment despite the fact that you are changing the constitution. So for example, Article 4, which is territorial changes. So this would require simple majority. Article 169. Once, if you remember, we studied something that said that the state legislative assembly will pass a resolution using using special majority 1, that they want a state legislative council. When the parliament actually creates the state legislative council, it does change a schedule in the constitution, but it would require a simple majority, because under Article 169 it is categorically given that it requires a simple majority. Similarly, under Article 243, if there is a parliamentary law that has to be made to extend Panchayati Raj institutions to scheduled areas or scheduled tribe areas, you would also require simple majority. Now, if you remember, I spoke to you about something called indirect federal impact. Indirect federal impact means still requiring special majority 3 will have a federal impact, but indirectly. So for example, when you're making changes to the union and the state judiciary under Part 4, Chapter 4, Part 5, Chapter 5, Part 4. For example, now that constitutional amendment has been declared invalid, the 99th constitutional amendment, which had added the National Judicial Appointments Commission, would be a part of this too, and it would require special majority 3. The Supreme Court had effectively struck it down. Similarly, if you're making changes because of Article 241 to 241 with respect to High Courts of Union Territories, you would still require special majority 3, because the High Courts are funded by the state governments. So it is going to be a burden on the state governments. And if you are changing Article 368 itself. So in a nutshell, are you changing the constitution? Yes. Is it a serious federal change? It's a non-serious federal change, a non-federal change, and is it a unitary federal change? If that's the case, then you would have simple majority. If it's a non-serious federal change or a non-federal change, special 2, and if it's a serious federal change, you would require special majority 3, because in all of these cases federalism is at its backbone. And after all of this, make any changes to any law of any nature, does not matter whether you add a law, you remove a law, an entire law, a provision of a law, you will require what is called simple majority. Ordinary bill, money bill, financial bill 1, financial bill 2, doesn't matter. So effectively, anything which is outside the purview of a constitutional amendment under Article 368 is effectively simple majority. By knowing this, you can plot any law whatsoever. You will know this by simply understanding this particular table. And this takes care of my topic, legislative changes. And now is time to quickly go through my 4 golden rules that you are absolutely aware of. These rules serve 2 purposes. 1, it helps you take educated guesses when you don't know what the question is. And 2, it reinforces an answer that you would have known but might be confused because of the stress of the exam. There are 4 golden rules. Number 1, democratic mandate. Number 2, federal balance. And 3 and 4, which are generally studied together, separation of powers and checks and balances. Every concept, right from the preamble to the very last article of the Constitution, is justified on these 4 golden rules. Let's start with rule number 1, democratic mandate. Democratic mandate says if you want to perform a democratic function, then you must have some form of democratic mandate. This function could be of any kind. This mandate could be of any kind. It could be a direct mandate, indirect mandate, full mandate, semi-mandate, any form. But some resemblance of mandate is required. Mandate means you have some affiliation to the people, which means higher the democratic function, higher would be the democratic mandate. Lower the democratic function, less advanced the democratic function, less advanced or lighter the mandate. Let's take a few examples. For example, for you to be a minister, you've got to be an MP. If you're not an MP at the time of becoming a minister, you've got 6 months to become an MP. Because as a minister, you're discharging the democratic function of executing policy, of formulating it, of initiating legislation. Those are core democratic functions. And the least we expect you to be is a member of parliament. Elected, nominated, does not matter, as long as you are a member of parliament. Because even if you are a nominated member of parliament, you could be from the Rajya Sabha, you're becoming a minister because the majority party in the Lok Sabha who gets to choose government wants you to be a member of parliament. Similarly, only elected MLAs participate in the Rajya Sabha elections. We used to have Anglo-Indian nominations, we don't anymore, but if that was the case, this is how it would be executed. And thirdly, let us say, elected members of the Lok Sabha, elected members of the Rajya Sabha, and elected members of the legislative assemblies of the state and the union territories participate in the election. Because if you're choosing a Rajya Sabha member, you're choosing the very first citizen of the country. The least we expect you to be is elected. This is also the reason why elected will always be superior to the appointed. This is why most of the outcomes of bodies of any nature are recommendatory in nature, because they're at the end of the day appointed bodies. It could also apply to an advanced concept as that of ordinances. Why are ordinances temporary laws? Because the ultimate law-making authority is still the legislature, which is why once the legislatures come back in session, they've got 6 weeks to pass the ordinance, and if they don't, the ordinance automatically lapses. This is why directive principles are not enforceable in a court of law, because you can't force the government to make a certain policy. So many applications from a simple principle which is called democratic mandate. My second rule is a federal balance rule. Now the federal balance rule has 3 sub-rules to it. Rule 1, or the first step, center stronger than the states. It could be in any form. The center would exert some form of superiority over the states. Then you will try to please the states, appease the states, make the states feel that they've not been wronged. And when you actually check the doing, you'll realize the pleasing and the appeasement was hollow. And ultimately, the center was still stronger than the states. Let me give you 2 examples. This is also a very widely used rule. Territorial changes. The states have no role to play or have no powers of territorial changes. So if I am dividing Uttar Pradesh into Uttar Pradesh and Uttarakhand, Uttar Pradesh Legislative Assembly has no role. So the center is stronger than the states. How do I appease UP? Because UP is going to be upset. The president, before introducing the bill to the parliament, and the president has to introduce, because the president is symbolically elected by both the center and the states, so the presidential recommendation is needed, but also at the same time, before the President recommends this reorganization bill to the Parliament, it will send the same bill for reference to the UP Legislative Assembly. Whatever the UP Legislative Assembly says or doesn't say, you can even put a time frame on it, is not binding on the President. So therefore, it is still hollow appeasement, and you would require all territorial changes to be passed through simple majority. You could also apply it to legislative relations. You have a union list, a state list, and a concurrent list, which means there is a clear division of power. But under extraordinary circumstances, the Parliament can make a law on something in the state list. How? If the Rajya Sabha authorizes the Parliament to do so. Now, the Rajya Sabha is a federal chamber, so the states are appeased. But ultimately, both the Lok Sabha and the Rajya Sabha will have to pass that law. Some cases, the center or the Parliament can directly pass a law on something in the state list if you are implementing an international agreement or an obligation of an international document. That's rule number 2, federal balance. Then you've got rule number 3 and rule number 4, separation of powers and checks and balances. Separation of powers and checks and balances are related to the 3 branches of government, the L, E and J, the 3 branches of state, the legislature, the executive and the judiciary. Now the legislature, executive and judiciary are to be treated separately and also interdependently at the same time. They are the centers of power. So separation of powers has 2 sub-concepts, inter and intra. Trying to keep the legislature, executive and judiciary separate because they are independent sources of power, and in our case, because of a parliamentary democracy, correlated because of the legislature and the executive is cut out from the legislature. You still have to keep them separate because they perform 3 separate functions. Intra means within the legislature, within the executive, within the judiciary. So for example, you have very strict conditions on joint sittings. This is nothing but intra separation of powers. The conduct of a judge cannot be ordinarily discussed in the parliament. The conduct of the parliament cannot be ordinarily discussed in a court, is inter separation of powers. So you have very clear-cut concepts that apply to separation of powers. And because they are the 3 highest sources of power, the only people who are capable of keeping a check on one another are the legislature, executive and judiciary. So therefore, you have inter checks and balances and intra checks and balances. The legislature, the executive and the judiciary keeping a check on one another is checks and balances, which is intra. The legislature, executive and the judiciary separate from one another is intra checks and balances. Take a few examples. For example, the power of the judiciary to review the laws made by the legislature is judicial review, is nothing but an instrument of checks and balances. Similarly, the legislature can pass, the Lok Sabha specifically, can pass a no confidence motion against the executive and could lead to the dismissal of the executive. This is also inter checks and balances. The Rajya Sabha has limited powers with respect to a money bill. It's an application of rule number 2 and intra checks and balances. The judgments of the Supreme Court are binding on the High Court is nothing but intra checks and balances. So you will see several concepts within the Constitution that will apply. Emergency, center-state relations, parliament, state legislatures, separation of powers, checks and balances, judicial review, territory, all of this will somewhere be centered around our 4 golden rules. And finally, the prelims tactics. These are again my creation, and they'll help you get the questions right more than anything else. My first tactic is the gray area. If your prelims question says, according to the Constitution, as per the Constitution, as defined in the Constitution, it must be in the Constitution in black and white. So there's a prelim statement that says, as per the Constitution, judicial review is the power of the court to review legislative action. Theoretically, it is right. Factually, it is wrong, because there is no word called judicial review in the Constitution. The first tactic. Second, the devil's advocate. Argue the opposite. If the opposite seems to be right, then therefore the primary statement goes wrong. Now, how does this work? For example, liberty is the absence of tyranny. So this means as long as there is no tyranny, there is definitely liberty. So does that mean democratic governments don't have difficult laws? They do. The statement is incorrect. Third, the reality check. Correlate to the most basic practical real life scenarios. Foreigners have a right to property. If foreigners didn't have a right to property, how would you have foreign direct investment? How would you have people settling in, running their businesses and home in India who were not Indians? So therefore, the statement is right. The sibling rivalry. A lot of times you will see statement 1 and statement 2 to be opposite of each other. For example, statement 1 will say, directive principles are enforceable in a court of law. The second statement will say, directive principles are not enforceable in a court of law. Both can't be right. Only one out of the two can be right. You will find these simple contradictions, complicated contradictions within the statements itself. Read them like a passage. And speaking of a passage, my final tactic, the simpleton. The simpleton idea is, at the end of the day, law is just fancy English. It's legal CSAT, if you would indulge me. So for example, you get a statement that says, a state is a community of people having independence with an authority to govern them, and therefore some amount of culture. Pick out the keywords. What we are referring to is state, we are referring to sovereignty, we are referring to territory, we are referring to culture. Is that the most appropriate definition? You must extract the keywords. And once you've extracted the keywords, what you have before you is the most shortened definition of state. So state generally means sovereign, government, territory, and people. If you find these 4 words simply extracted from the option, what you have is the right option. And these are my 5 prelims tactics. With this, we finish the first lecture, and see you soon in the next lecture. Thank you for watching. Every possible legal concept, theory, doctrine, anything that you could possibly think of would effectively be in and out of this fairly complex looking diagram, but it really is not. The journey would start with rule of law. I'll explain to you the ingredients of rule of law. We'll go through each of the ingredients of the rule of law in detail. And while we do so, I'll also explain its related applications. And the concept of constitutionalism is effectively based on rule of law. And there are some dominant themes of constitutionalism which overlap with rule of law. We'll cover them in the course of the lecture as well, and we'll apply them as we get to do so. So let's first understand this matrix. I'd like to believe that rule of law is the big bang of constitutional law. it's the big bang of law in general. It's the Higgs boson. It's the start of everything else. It all starts honestly with a very simple choice. The choice is, do you trust the person in power, or do you trust the office that the person holds while the person is in power? So the decision of rule of law actually begins with a simpler decision of rule of man versus rule of law. Now, rule of man simply means that the person in power gets to do exactly what they want to. And rule of law means everything is governed by a law. The law is also made by the man. The law is also made by representatives. But the law is more important than the people who have the power to make the law, implement the law, or adjudicate the law. And that's a distinct difference. The Latin interpretation or the Latin translation of rule of law is lex rex. The Latin translation of rule of man is rex lex. So every country would effectively be choosing what is called between rule of man and rule of law. And most democratic countries, and this is the important part, democratic countries will necessarily choose rule of law. If you are a democratic country, that means rule of law is something that you would compulsorily want to choose. Why? What is the relationship between rule of law and democracy? If democracy is reflection of public will, if democracy is about ensuring that the aspirations of the people are reflected in the government, if democracy is about the people choosing the people who will govern them, then rule of law ensures that the people in power do the right thing in the right way, in the right manner, for the right reasons. And that is why there is a positive correlationship between democracy and rule of law. Now, there would have been several reasons for several countries to choose between the two. And India chooses to be a rule of law country for primarily 4 reasons. Reason number 1, our colonial history. Approximately 200 years of colonial rule, and the legal part of it, the constitutional legal history, would be dealt with in the forthcoming lecture. The colonial part of it made us understand how perverse and how difficult, irregular, biased organizations of government can be. We know the detrimental laws, the biased laws, the one-sided laws that the Britishers have imposed upon us. And therefore, we always wanted to ensure that we have a fair system of government. 2, unlike several Western countries, more specifically the United States, where the states collectively came together and said, let's make the United States of America. The states came before the center when it comes to the US. In India, it was the exact opposite. In India, power was transferred to the Constituent Assembly, and it was the responsibility of the Constituent Assembly and the leadership at that time to consolidate and integrate India. Now, for those reasons, India is partially a voluntary federal nation and partially, one could say, semi-involuntary. There were a lot of instances where there was a lot of hesitation, there was a lot of resistance, there was certainly a lot of negotiation. So if you have to convince a princely state to join India, you cannot convince them by saying, you know what, we've got a great leader in power. You've got to convince them by saying, our relationship is going to be governed by a law that's going to be bigger than the people in power when the law is to be operated upon or when the law has to be executed. So, our reasons of voluntary and for voluntary federalism is a very strong factor in India choosing to be a rule of law country. Thirdly, the sheer diversity quotient makes rule of law an obvious choice. The diversity quotient means, unlike again several countries in the West, India has always been home to all religions, all cultures, all groups. We've always been an incredibly diverse country. We have always been an incredibly welcoming country. So, whenever there is diversity, there will always be a majority, there will always be a minority. And whenever there will be a majority and whenever there will be a minority, no matter what kind of a majority, no matter what kind of a majority or a minority, it doesn't matter what the nature might be, diversity will always have the chance of conflict. In such a case, the law must be indiscriminate. The law must be fair, the law must be unbiased. And if actual power is with the law, it will make sure that the majorities don't cross a line and the minorities are adequately protected. But if the person in power has all the law, has all the power, has all the authority to do whatever they want to, then depending on who the person in power is going to be, and democracy is nothing but the law of majorities. So generally what would happen is that a person in power would necessarily, or if not necessarily, most likely come from a majority. And that could be leading to some questionable policy outcomes. So India chooses to be subject to a bunch of laws. Those laws that will stop the people in power from crossing a line and will make sure all interest groups are adequately represented, protected, and taken care of. And fourthly, our socio-economic indicators. When we became independent, as per our first census, which was I think conducted in 1951, India's literacy rate was about 15-16%, which means 85% of India could not functionally read or write. The female literacy rate of India was under 9%, which means about 91% of India could not read and 91% of women could not read and write. Now, in a circumstance like that, where literacy is so disadvantaged, where poverty is so disadvantaged, where there are several other developmental challenges, rule of law becomes an equalizing factor. It will protect those in a larger capacity who need more advancement. It will make sure there is some form of equivalence of opportunity, of platform, of ability, of a chance to redeem oneself. And for these four reasons, we choose to be what is called a country based on rule of law. Now, very categorically, the word rule of law is not mentioned anywhere in the Constitution, though the Supreme Court, in a variety of its judgments, have recognized rule of law as a concept. In fact, we also recognize rule of law to be an element of basic structure. But the word rule of law per se does not find any mention whatsoever in the Constitution. It is a Diceian concept, and Dicey was a very, very prominent English legal expert. The full name was A.V. Dicey. It's not relevant for the prelims exam in any manner. So when he had originally written what the concept of rule of law is, he had kept the UK's legal system in mind. And what we know about UK's legal system is the fact that they don't have a single written codified constitution. They were, at least at that time, a functioning monarchy with at least some substantive powers. So the original Dacian understanding of rule of law versus what is the globally accepted uh, principles of rule of law, there is a little bit of a difference. So, based on Dacian concepts of rule of law, which you would also see similarly in several Indian manuscripts and Indian texts also, there are three basic principles of rule of law, three basic pillars of rule of law. The first of it is called the lack of arbitrariness, the absence of arbitrary power. It is the first and the most important rule of law. When we use the word arbitrary, arbitrary simply means when somebody is doing something on their own. There is no substantive law that is allowing you to do something. You are doing it because you think it is the right thing to do. You are applying your mind or not, but you're independently taking a decision which sounds without any justification. There's not enough rationale for you to do what you want to do. And therefore, arbitrariness is one of the most important dangers to the concept of rule of law. Now, when we say this, what do we mean? We mean that if there is an arbitrary law, or if there is an arbitrary action taken by the executive, which is largely the case, then the law as the supreme of it, the law as the heightened concept of it, the law as the superior entity to it, that loses its charm. When we say rule of law, it means everything happens because of a law. When we say rule of law, means every power originates because there is a law that provides for it. For example, in a few lectures from now, when we do the executive, I will say that the executive powers of the union are coextensive with the legislative powers of the parliament. That's simply an application of rule of law. The powers of the executive to implement the law will only be limited to the powers of the parliament to make the law, which simply also means that the executive can only implement those things on which the parliament can, has or would have made a law on. And that's the larger idea. So the law is the originator of power. If there is no law, what you're effectively being is arbitrary. So it becomes a very, very important concept. So this means when we speak about arbitrariness, it actually applies more to executive action and a little less to legislative action. So arbitrariness is largely associated also with administrative law. It's also associated with a more complicated concept like delegated legislation, when the executive is empowered to make rules on something. Are they crossing a line? Are they making rules on something that the law has not given them the powers to make rules on? So, for example, if there's a right to education rules, it's because the Right to Education Act allows for the right to education rules. But the right to education rules that you've made should be because of what the Right to Education Act allows the Education Ministry to make rules on. So therefore, it is a very, very sensitive concept, extremely important. And therefore, when you have to eventually prove arbitrariness, you would therefore be dealing with two very important legal concepts. First, are you following a procedure which has been properly passed by the law? And second, is the law and the procedure inherently fair or not? And that's why you have procedure established by law and due process of law. Two very, very important interpretations and two very important terms. In fact, procedure established by law is explicitly under Article 21, but due process of law has been interpreted by the courts in several decisions. The most important of it, the most landmark of it, happens to be the Maneka Gandhi case. So, when you are trying to figure out whether the procedure was fair or not, you have to figure out where there was a conflict of interest, or whether you had given an adequate opportunity to the other person to present their side of the story. So, therefore, related to the due process of law, you would have a concept called principles of natural justice, and this is directly related to arbitrariness. Now, procedure established by law and due process of law also ensure the law is good enough to rule us. For there to be rule of law, the law should be worthy enough to rule over us. And therefore, if the law is procedurally sound, the law is substantively sound, then the law is good enough to be above us. And that's also why these become very important hallmarks of rule of law. So, which is why you'll see the journey starts from rule of law, comes to arbitrariness, that for there to be rule of law, there should not be any arbitrariness. And how do you ensure there is no arbitrariness? Is by making sure there is procedure established by law and there is due process of law. Are we okay with this? Do we understand this? And if that is the case, to prove due process of law, you must be able to also attach the larger concepts of principles of natural justice. So the journey starts from rule of law, comes to arbitrariness, comes all the way to procedure established by law and due process of law. This is one arm of it. The second arm of rule of law, the second pillar of rule of law, is equality before law. The law cannot be superior to us if it doesn't treat us equally, if it doesn't treat its subjects equally. And very happily, what you have is equality before law categorically mentioned under Article 14 of the Constitution. So this effectively means that the law should not treat the government specially. The law should not treat government servants specially. There should not be an unnecessary amount of immunity unless it's absolutely necessary. So rule of law is heavily dependent on what is called equality before law, because equality before law means that everyone is treated equally before the law. And of course, over a period of time, you'll understand equality just doesn't mean everybody to be treated equally, but it also means that people who should be treated equally are treated equally, and people who are different, who are disadvantaged, where there are special circumstances, and therefore there could be some amount of what is called differentiated treatment, which is why when you study equality before law, you also in the Constitution also understand two very important concepts. Again, both of these concepts are not explicitly mentioned in the Constitution, but have been derived through several Supreme Court judgments, and they are rational nexus and intelligible differentia, which means that by chance, for any reason whatsoever, you are not treating two people the same way. The first question is, the basis on which you're not treating two people the same way, is that basis reasonable? So therefore, rational nexus. And by treating two people differently, you're trying to achieve an objective. So if you are treating two people differently, are you necessarily able to achieve that objective? So for example, let us say your objective is social justice, which means that people who come from disadvantaged castes must be given some relaxations, some special provisions. So you have basically bifurcated people on the basis of, let's say, upper caste and lower caste. Is that a reasonable basis? Sounds like it. By doing this, if you're able to ensure that people from lower castes are able to get better employment, better reservation, better opportunity of education, then it sounds about right. So, therefore, equality before law allows you to have some form of equity before law. And the two principles would be rational nexus and intelligible differentia. And both of these, again, are not mentioned in the Constitution, but of course would find some important mentions in several Supreme Court judgments. Now, the third principle of rule of law, as we understand it to be, is the grand old legal spirit. What is law without the legal spirit? But what is the legal spirit? The legal spirit is your ability to go legal. For you to go legal, you've got to have rights. And not only should you have rights, you should also have a mechanism to enforce those rights. You should have the ability to challenge something if it takes away your rights. You should have the ability to question authority, to question government if your rights are being taken away. So legal spirit is effectively the ability or the being to have some legal recourse, some legal correction. And for that to happen, you should have the courts in the country with the powers to review something that is taking your right away, more simply called the concept of judicial review. But again, judicial review is also not categorically explicitly mentioned in the Constitution. It is derived from various articles. It is in fact a part of basic structure. It is extremely important in terms of ensuring checks and balances, which is a natural corollary of separation of powers. But the term judicial review, as the term stands, is nowhere mentioned in any form or manner as far as the Constitution is concerned. And for the courts to be able to independently, for the courts to be able to efficiently review anything that has taken your right away, it mostly would be a law or an action by the executive. In such a scenario, you would effectively require an independent judiciary. A judiciary which is not biased, a judiciary which is not having any compulsion whatsoever to favor a certain side. Again, the term independent judiciary is nowhere mentioned in the Constitution. It is derived through various provisions. One of them could effectively be the collegium system of appointment. And we do recognize independence of judiciary, in fact, as basic structure. In fact, it was because of independence of judiciary being basic structure, we struck down the 99th constitutional amendment as being unconstitutional, as it had proposed an alternate system of appointment to judges, which would involve the legislature and the executive. This alternate system would therefore be called the National Judicial Appointments Commission. So yet again, for there to be rule of law, you should be able to question anything which is taking away your legal rights, and therefore that's called legal spirit. And for you to be able to do that, you should be able to have judicial review and independent judiciary. So if in the prelims they ask you which of the following is an outcome of rule of law, and they say rule of law is related to judicial review, yes, because without judicial review there cannot be rule of law. You cannot decide what is good law or bad law unless there is judicial review. And for you to decide whether there is good law or bad law, you should have what is called independence of judiciary. Now, these are the kind of questions the prelims has been asking of late. They're taking a grand concept and they're linking it to very, very tangible constitutional principles. So therefore, rule of law has three major pillars. Each of these three pillars will have a degree of applications. Now, if rule of law means that the law is more powerful than the people who are implementing the law, and the people who are implementing the law are effectively the state. So the rule of law is effectively a mechanism to limit the powers of the state. And the theoretical understanding of anything that limits the powers of the state is the concept of constitutionalism. And constitutionalism allows you to restrict the powers of the state, allows you to build whatever you can, however you can, to restrict the powers of the state, which is why rule of law is actually the basis of constitutionalism. So there cannot be constitutionalism if there is no rule of law. And this is true because if constitutionalism is to restrict the powers of the state, then the legislature, the executive, and the judiciary are branches of the state. Giving any one of them any superior power of the other will take away the balance, and therefore it should ideally be the law which restricts the powers of the state, and therefore rule of law becomes that entity that restricts the power of the state. And when you build a constitution which is an application of constitutionalism, is nothing but rule of law in very tangible form, which is why the Constitution gives reference to procedure established by law. It's through the Constitution you come up with things like the rational nexus. It is through the Constitution that you're able to come up with things like judicial review. So, therefore, what ends up happening is rule of law is the basis of constitutionalism, yes. And constitutionalism restricts the powers of the state, yes. And therefore, anything which leads to supremacy of law and leads to limiting the powers of the state is effectively interrelated. So, for instance, if the law is arbitrary, that means the law is not treating people equally. And if the law is not treating people equally, it is violating a legal right. And therefore, I have the powers to review that law, and I will be able to do it effectively only and only if I have an independent judiciary. And if the law is treating us unequally, that means either the basis of classification is wrong, or the objective that you're trying to achieve with that classification seems to be odd. And when you do all of those things, you're effectively questioning the way in which the law has been passed, or the way in which the law is being applied, or is the law inherently good or not. So the circle gets completed. So this rather seemingly complex flowchart is actually the heart and soul of the Magna Carta, Indian polity, Constitution, and everything else. So think of any constitutional principle that comes to mind. Let's say federalism. Now, federalism is division of powers between the center and the states to ensure what? There is no arbitrariness. And this means that rule of law has a relationship with federalism. And constitutionalism is limiting the powers of the state. The state includes the center and the states. So if I divide powers between the center and the states, what I'm effectively doing is limiting one's power over the other, which is nothing but, again, constitutionalism. So constitutionalism, so federalism applies to arbitrariness, applies to constitutionalism. Take, for example, doctrine of basic structure. Doctrine of basic structure applies to the parliament's power to amend the constitution. They cannot randomly, arbitrarily amend whatever it is that they feel like. And therefore, if they cross a line, if they violate a doctrine of basic structure principle, then Because of legal spirit, I can review whether that actually violates the basic structure doctrine. And for me to tell you what is an element of basic structure doctrine or not, I've got to have an independent judiciary. Something as large as federalism or basic structure to something as simple as the powers to issue an ordinance by the president is coterminous with the powers of the parliament to make laws, is nothing but rule of law to ensure there is no arbitrariness, and in case there is a problem, there is legal spirit which allows you to judicially review. So the fact of the matter is, this is the Big Bang. Everything that happens because of this ecosystem. Now let's break this ecosystem. Let's look at each fragment in a fairly decent amount of detail and understand exactly what each of these mean. Why is this important? And arbitrariness largely looks at executive action. When we say that the law is treating two people differently, therefore it's violating equality before law, it largely looks at legislative action. And the legal spirit looks at the powers of the judiciary. So through the three pillars of rule of law, you're able to identify the three branches of the state. Every possible combination running from one point to the other is possible because of this matrix of constitutional universe. Now with this, we start with the first pillar of rule of law, which is arbitrariness. Now, let's understand arbitrariness. As you were discussing before, arbitrariness is simply when you are applying your mind or not by simply you doing so. There is nothing that tells you to do this. You are doing this on your own accord. So therefore, arbitrariness is largely related to executive action. Now, the executive is doing something. What the executive is doing could be because of two reasons. Reason number one, very simply, would be that there is a law that gives the executive authority some arbitrary power. This is a prelims previous year question, by the way. The question was, if there is a law that gives uncontrolled arbitrary powers to the executive to do something, what does it violate? So what is happening is, the law is giving an authority the power to do something arbitrary, which means the power is flowing from the law. And this is also violating equality before law. This is also violating the fact that the law should be fair and unbiased. So whenever the law is giving executive authorities an arbitrary power, it always violates Article 14. So for example, let us say when there were challenges made to the Prevention of Money Laundering Act because of the kind of powers it had given to the Enforcement Directorate, allegedly the Supreme Court of course upheld the act, but the challenge was effectively on Article 14, that it was giving wide powers, powers which were unreasonable to an executive authority established because of a law called the PMLA. Similarly, sometimes, very, very rarely, the executive authority will do something when there is no law providing for it. You are punishing somebody, taking action against somebody, you're illegally arresting somebody, you're illegally detaining somebody, you are illegally confiscating somebody's property. Under no law do you have the powers to do this. And therefore, when you decide to do this, you are doing this not because a law is giving you the powers to, because you as the executive authority has assumed the powers to do so. It would largely be a violation of Article 21 because you are effectively violating the life or personal liberty of somebody, and there is absolutely no procedure under the law that allows you to do so. So arbitrariness and equality before law have Article 14 in common. They're conjoined because of Article 14. So when I look at the constitutional reflections of it, Article 14, therefore, strikes at the heart of arbitrariness. So whenever you are actually questioning that a law is arbitrary, you will actually be quoting Article 14. And that is why one of the aspects of proving arbitrariness is intelligible differentia and rational nexus, which leads to a larger doctrine called the doctrine of reasonable classification, which of course we will do more in detail under equality before law, because that's closer to Article 14. But arbitrariness and Article 14 have a very deep relationship, because if a law is treating people unfairly and there is no good enough reason for the law to treat people differently, that means the law is being arbitrary. That means the executive authority, who has been given the powers under the law to do so, is doing so in an arbitrary manner. And in case the executive authority is doing whatever it wants to, and there is absolutely no law that allows you to do so, for example, an illegal detention, that means you're violating Article 21. That's also against arbitrariness. So arbitrariness would be proved through 14 and of course through 21. Another deduction of this in the Constitution would be Article 245, which effectively is correlated to the 7th schedule, which contains the union list, the state list, and the concurrent list. Now, what happens with the union list, the state list, and the concurrent list is they very clearly divide the powers between the center and the states. By doing this, you make sure that anything any state government or a central government wants to make a law on can only do so if it is within their specific respective lists under the 7th schedule. And the second you cross that, you have not only violated the constitutional scheme of division of legislative powers, you've also been arbitrary, because you do not have the power to make a law on it, nor do you have the power to, as an executive authority under the center or the state, to implement something that you do not have legislative backup for, in a manner of speaking. So center-state relations is a very important instrument of, for example, absence of power. And the applications of absence of arbitrary power is effectively immense. So for example, in a way, when you decide to have very clear-cut jurisdictions, the courts can do X, can't hear Y, locus standi principle applies, doesn't apply here, doesn't apply there, jurisdiction, all of those things. It is all largely an impact of what is called absence of arbitrary power. Because if the courts can arbitrarily decide on something, that is also equally a problem. However, in most cases, in a majority of issues, arbitrariness is largely a mischief done by the executive. Of course, you would have in some cases the legislature also doing something arbitrary, but when the legislature does something arbitrary, it hits Article 14 more than the executive doing something arbitrary. What I'm effectively trying to say is, whenever there is arbitrariness by the executive, it will hit Article 14. When there is arbitrariness by a law, by the legislature, it will hit Article 14 more. At the end of the day, 14 is the midpoint between the first two pillars of rule of law, which is the absence of arbitrary powers, and what is also effectively called equality before law. But what we've understood very clearly here is that yes, arbitrariness is when you're doing something without sufficient reason for it, without sufficient legal backup for it. Whenever you do something like this, you are being arbitrary. A closely related word to arbitrary is discretionary. Now, discretionary is a good way to look at arbitrary. A discretionary power means you have the right under the law to effectively do something on your own by applying your own mind. And therefore, discretionary power is effectively a power which you are using because the law, by directly or indirectly, tells you to do so. For example, the Constitution gives the governor constitutional discretion to set, say, reserve any bill the governor wishes for the assent of the president. Now, that discretion is in fact mandated by law. If the discretion is unreasonable, if you are using your discretionary power in an unfair manner, then it could be arbitrary. So whatever is discretionary is not necessarily arbitrary. But yes, if there's something which is arbitrary, it's because largely they have been coming from some discretion that has been exercised. And in a welfare country like ours, especially the role of the civil service is a career that you aspire to, so rightfully one could say that in a socialist welfare country like ours, discretionary powers are sort of a necessary evil. Otherwise, it will be very difficult for the bureaucracy to do what it has to do if they had to be bound by every nitty-gritty provision contained in the law. So this is the first pillar of rule of law, and now we move to the second pillar, which is equality before law. Unlike the first pillar, which is absence of arbitrary power, equality before law dominantly applies to legislative action. When a law is being discriminatory in any reason. Now, it can be positively discriminatory and negatively discriminatory. When it is negatively discriminatory, we call it equality before law, which simply means everyone is equal before a court of law. Doesn't matter who you are, doesn't matter how rich or poor you are, doesn't matter what caste, creed, color, religion, gender you come from, doesn't matter if you're a part of the government or if you're an ordinary private citizen. It is effectively, very categorically reflected under Article 14. And Article 14 also tells you that everybody is not inherently equal. That is a more advanced, a more nuanced meaning of equality. You cannot have someone with high-end sport shoes, fully capable, fully abled, and someone who is disabled and and wearing nothing but just on their bare feet running the same race. There is an inherent disadvantage. So you have to treat different people, you have to treat people who come with different abilities in a different manner. This is called equal protection of law, also categorically mentioned under Article 40. Now, equality before law is a very straightforward application of rule of law. The relationship is, if the law has to be competent to be superior to everything else, that means the law must also be egalitarian in nature. The law in itself must be equally applicable to people irrespective of scenarios. Sometimes scenarios make it compelling for the law to be discriminatory. And let's understand this through some constitutional reflections. So, under the principle of equality before law, it says like should be treated alike, which means everyone who is similar to each other should be treated similarly. But that also means that, for example, let's say there is A and B. They're inherently different. Now there is B, there is C, there is D, there is E. B, C, D, E are different from A. Now does that does not mean that B, C, D, E should be treated similarly. Unlike should not be treated alike. This is a concept of equal protection of law. This is also the birthplace of affirmative action. This also allows for reservation policies to be there. It is a very, very important, nuanced principle, and thankfully, both equality before law and equal protection of law are explicitly mentioned in the Constitution, which now raises the larger question. And the larger question is effectively this. The question is, all right, I am allowed to treat people differently. How do I do so? For that, the courts have come up with the doctrine of reasonable classification. For you to be allowed to be treated differently, you should be able to fulfill two principles that collectively constitute the doctrine of reasonable classification. If you are treated differently, as I was telling you before, what is the basis of it? And second, what is it that you're trying to achieve? If the basis is reasonable, and by doing so, you're able to achieve something which is also reasonable, the objective is good enough, and by doing this you're achieving the objective, it's called rational nexus. If the basis is reasonable, it's called intelligible differentia. You would apply this concept to adultery, to homosexuality, to positively to reservation, everything possible. Article 14, as we will discuss when we come to the subsequent lectures on the same, is the backbone of any constitutional challenge. It is underrated, which is why Article 14 is a prelims favorite topic. Not as much for the mains, because in the mains you will see 19 and 21 to be the stars of the show, because issues directly originate from there. But Article 14 is where the constitutional complexity and the constitutional conceptualization lies, which is why Article 14 and issues around these are an absolute prelims favorite. So therefore, if you're doing this, you have to fulfill reasonable classification. It could apply to a presidential immunity under 361. It could apply to an immunity to report true legislative proceedings under 361A. It could apply to diplomatic immunity. It could apply to parliamentary privileges. As I said, it could apply to adultery, to homosexuality. It could apply to right to education in private institutions. Literally everything has to be true, has to pass equality before law. The third principle is that the law itself should be fair, which is exactly what we've been saying for all this while, that for there to be rule of law, the law must necessarily be good enough. And for the law to itself be fair, reasonable and just, you add Article 21 with a little bit to Article 14, and you come up with the concept of due process of law, which has been evolved and applied. It's a US concept, evolved and applied to India through the Menka Gandhi case. Of course, the differences between due process of law and procedure established by law, I will do in greater detail when we do preamble, rights, duties, directive principles. But from a concept point of view, I think this is something that we must know. Now, so this means that arbitrary power plus equality before law is somehow leading us to what is called due process of law, because arbitrary power or the absence of arbitrary power means that there is nothing which is unfair, unjust, unreasonable in the way an action has been executed by the executive. The law itself should also not be unfair, and you add both of these concepts together, what you effectively get is due process of law, which is why, and this is also why last year in 2023, There was a remarkable question, so let's address it in detail in line with PYQ trends. So when we are referring to due process of law, we are trying to say that that anything will pass the test of due process of law if it is able to prove no arbitrariness in executive action and or no arbitrariness in terms of the law. The law is not unfair, the law is not unreasonable, the law is not unjust, the executive has not been arbitrary in implementing it. If either of the two or both are being fulfilled, then you would have what is called due process of law. Now, the larger umbrella term is due process of law. What the Constitution under Article 21 mentions is procedure established by law. Now, to explain the difference between them, I'll take a simple example. So we understand that there are three branches of the state, L, E, and J. That's one parameter. And in the first lecture, you would have understood there are two kinds of laws. One is called a procedural law. The second is called a substantive law. So let me tell you, let's say, for example, let's make a law today, and let's say drinking tea in the afternoon is a crime. Now, this is a substantive law. And if I make another procedural law and I tell you that if you have been charged with drinking tea in the afternoon, you will not get any legal representation. You don't have the right to hire a lawyer. You will not have the right to be represented by a lawyer in a court of law. So this effectively means that this is a procedural law, this is a substantive law. Now keep this in mind, and now let's understand the three basic versions of it. The first is the pure form. I call it pure due process or procedure established by law. This means whether both of these laws were passed in the right manner. No matter what is inside the law, if the law is passed in the right manner, both the houses passed it, the president gave the assent, published properly in the Gazette, all done, all procedures taken care of, it doesn't matter what is inside the law. It's a very narrow understanding, but it's the textual understanding, which basically means that as long as the law has been passed using the right procedure, as long as the law or any restriction which is effectively based on some law which has been passed in the right manner, the procedure has been rightly put into place, as long as that happens, you are good to go when it comes to procedure established by law. This also means that it is largely applicable only to the executive. Now understand this. If I tell you from a very simple textual meaning of procedure established by law, it means, let's say something has violated procedure established by law, which means the law tells you there is a procedure, the authority has to implement that procedure, the authority has not implemented that procedure, the authority is the executive, which is why procedure established by law is only and only applicable to executive action. For example, let us say there is an income tax law under which an income tax authority has the right to, let us say, inspect your documents. But before they do that, they have to send you a notice. If they don't send you that notice, they have violated a valid procedure established by law. That's what it means. It is explicitly given under Article 21. So by this reason, both of them are perfectly okay. There's nothing wrong with both of them, because both of these laws were rightfully passed using the right procedure and are being implemented the right way. So therefore, you need to make this better. Just because something has been passed the right way does not necessarily mean that it is right. Tomorrow I could make a law saying growing a beard is criminal. I would be in jail. So therefore there is a problem there. Or let's say if I grow a beard and the police could just take me and put me behind the bars without allowing me to contact, let's say, my relatives. There's something wrong with the procedure. There's something inherently, fundamentally unfair about that procedure, which is why you need to take a step up. And that's exactly what happened in the Maneka Gandhi case, where the Supreme Court said, irrespective of the fact that the procedure was rightly passed and the procedure was rightly followed, but was it the right procedure to follow? Is the procedure in itself a good procedure? The fact that you do not have any legal representation, is that okay? Is that justified? Is that all right? Is that acceptable? The answer is a clear no. So therefore, according to procedural due process, or PEL plus, this procedural law can be declared invalid. The basic understanding is procedural due process applies only to procedural laws, and therefore procedure used to implement the law, is that procedure fair or not? So that is what is meant by procedural due process. Now, is the procedure fair or not? How will you know? When I don't give somebody legal representation, I don't give them the right to be heard. I don't give them the right to a fair trial, the right to a fair hearing. And all of this is a part of a larger principle called principles of natural justice. And this also links straight up to constitutionalism, straight up to rule of law. Which is why in 2023, when they asked you, PEL plus is effectively nothing but was the procedure inherently okay or not? And this is your titanium line for the prelims exam. Procedural due process, as defined by Maneka Gandhi, is only and only applicable to procedural laws. So in the Passports Act 1967, which gave the powers to the government to ask Maneka Gandhi to surrender her passport, the Passport Act was questioned because the Passport Act did not allow for her to actually give her side of the story. It was an unfair procedure, which is why it is procedural due process, which is closely linked to principles of natural justice, which I will now discuss in just a few minutes on the next page. And then you have the best of it all. Is the procedure fair or not? And is the law in itself good or not? Is it okay to criminalize having tea in the afternoon? Does it even make sense? Why would you criminalize having tea on a hot, lovely afternoon in the winters? That is just wrong. That is just unfair, unjust, and unreasonable. So this is something that will therefore apply to both procedural and substantive laws. Maneka Gandhi's case did not speak about this. It spoke about this. And therefore, when you're questioning the law itself, that means you're questioning the substantive law. Law says X is wrong, but that doesn't seem right. Why should X be wrong? That is called substantive due process. Now, this has been used on so many occasions in so many different ways, means, and forms. For example, 1978, just a few months after Maneka Gandhi's case, in the Sunil Batra case. Here, the issue was that a person who was to be convicted and therefore sentenced to a death penalty would be kept in a separate prison. Doesn't seem to be a fairly right thing to do. Constitutionality of the death penalty. It seems unfair, unjust for the state to take away your life when the state has not given you life. Decriminalization of homosexuality. It is unfair, unjust, and unreasonable to criminalize people who are privately being intimate with people of the same gender. It could apply to transgender rights. It could apply to entry of women into the Sabrimala temple. It could apply to abortion rights. It could apply to privacy rights. It could apply to Section 66A of the IT Act. Anything and everything which declares a fundamental law to be invalid because the substantive law is fundamentally unfair is what is called substantive due process. Now, going back to 5 minutes ago when we were speaking about principles of natural justice. Principles of natural justice is to check the fairness of the procedure, is to check whether the procedure is fair or not, is being applied fairly or not, is the procedure inherently a good procedure or not. It's not about the substantive law, it's about whether the procedure is okay or not. So for example, you're questioning the way the ED would function, or for example, you may want to question the way the CBI would function, you may want to question the way any other intelligence agency would function. That is, or let's say issues with the NIA Act, for example. So your issue would be with procedure. But if you're questioning whether the Unlawful Activities Prevention Act powers to declare an organization to be unlawful, is that fair law or not, that would be substantive due process of law. So now let's take a magnifying glass and let's look at principles of natural justice. Now, because there's been reference here, let's understand quickly. Procedural due process, or PEL plus, means is the procedure fair or not. It means whether the procedure has been fairly applied or not, is the procedure inherently reasonable or not, which leads to my larger principles of natural justice. Now there are two Latin terms, nemo judex in causa sua and odi alterum partem. It simply means rule against bias and the rule of a fair hearing. So which means if there is any conflict of interest in any form, in any manner, there could be favoritism, that could be a positive bias, there could be a negative bias. For example, one of the things that contempt of court is severely criticized for is effectively rule against bias, nemo judex in causa sua. Because what happens in contempt of court is you've disrespected the court and the court is initiating contempt proceedings against you. The person that you have harmed is the person deciding whether they have been harmed or not. There's a clear conflict of interest. So there could be a personal bias, there could be a pecuniary bias, there could be a substantive bias, there could be an administrative bias. So any bias of any kind, any conflict of interest of any kind is effectively a violation of principles of natural justice. And then you have something called the rule of fair hearing, which simply means you have the right to be heard, you have the right to question evidence, you have the right to be shown the kind of inquiry that has been committed against you, you have the right to know why you've been charged with something, which is why, for example, Article 22 is a huge question mark on the rule of fair hearing, because under preventive detention you do not have the right to seek a legal counsel, because preventive detention goes against the fundamental concept of a fair hearing. And with fair hearing, there are two concepts. One, there's something wrong that you've done. Before finally deciding what you've done is wrong, they have a hearing. This is called pre-decisional hearing. The second way to do this is, you've done something wrong, and therefore they've decided that you've done something wrong, and they've taken action against you. Now, after they've taken action against you, then you can question the action that has been taken. So preventive detention is actually an issue of post-decisional hearing. It's also included in odi alterum partem. In fact, in the Menka Gandhi case, this was exactly the problem. She was asked to surrender her passport, she was ordered to surrender it, and then she was asked, oh, by the way, do you care to explain yourself? So these are your two basic principles, and in the modern world that we live in, we also now have a modern principle of natural justice, which is nothing but the doctrine of reasoned decisions. Now, the doctrine of reasoned decisions, as we understand it to be, is that if somebody is giving a decision against you, they've also got to tell you why they're saying so. They've got to tell you what is the basis on the basis of which they've said you are wrong, this is why you are wrong. Of course, in all of this entire ecosystem, there will often be some terms and conditions. For example, an emergency. For example, a specific law that provides you or exempts you from, let us say, you know, the right to a fair hearing, or the right to be heard. There could often be cases where administratively you could be prevented. There are enough and more exceptions that can happen on a day-to-day basis. But largely, again, because procedural due process or procedural fairness largely applies to procedural laws, and the problem is that procedural laws are largely executed by the executive, you will mostly see principles of natural justice applied to executive actions. It could apply to other also, but mostly it is done so for executive actions, which is why Article 311 Clause 2, wherein a civil servant, you are constitutionally protected that you cannot be removed without an inquiry against you, is nothing but a principle of natural justice. The problem with 3112 is, do you get to be shown a report of the inquiry against you? That becomes a question mark on the principles of natural justice. Nonetheless, these are your three pillars of what I call rule of law, what the world calls rule of law, with applications to real-time constitutional principles, just the way UPSC asks them in their prelims exam. From here, we now move to the legal spirit, the third and the final pillar of rule of law. Now, as I said, legal spirit is the spirit of being legal. Now, this effectively means two things. One, not only do you have rights, but you also have enforceability of rights. If you don't have rights, you don't have a legal spirit. Rights is a form of guarantee. Unless you don't have a right, you don't have anything to go to court for. And A and B, you have a right, but you don't have a right to enforce that right is a problem. So enforceability. And generally how your rights are violated. They're violated because a law is wrong or an executive is wrong. And that is the larger concept of judicial review. Judicial review means two things. One, the review of legislative action, and two, the review of executive action. Of course, the courts also evolve. Also, lower courts' decisions are reviewed and appealed by higher courts. So generally, when a higher court is reversing a judgment of a lower court, we don't use the word judicial review because you have what is called an appellate system in place. We have an independent and an integrated judiciary, and the higher courts, the Supreme Court and the High Court, are courts of record. This is something that I'll teach you in more detail when we do judiciary, but basically a court of record is something which is to the effect that anything presented before the court is a part of substantive proceedings and substantive record of the court. And two, the courts have the power to review their judgments, to keep evolving their judgments. All of this is in the larger spirit of something called the legal spirit. So whether it's court of record, whether it's suo motu, whether it's PIL, whether it is, when we look at from a constitutional reflection point of view, Article 13 Clause 2, which says no law can violate a fundamental right. which means if a law violates a fundamental right, the courts figure out whether the law was right or wrong. Similarly, if your fundamental right is violated under 32, you could go to the Supreme Court. This is an enforceability law. If any legal right has been violated, or even if your fundamental right is violated, not only can you go to the Supreme Court in case of a fundamental right, you also have the option and the choice to go to a High Court. If your fundamental right is violated, you also have the option to directly go to the Supreme Court. In case your constitutional right or a statutory right or a legal right is violated, you can go to the High Court under 226, which is again nothing but an enforceability clause. The jurisdiction of the courts, original jurisdiction, advisory jurisdiction, extraordinary jurisdiction, appellate jurisdiction, writ jurisdiction, all of these are nothing but instruments of legal spirit. So if they ask you, for rule of law, Article 32 constitutional remedies is a natural outcome, that is a perfectly valid statement, because if you don't have the powers to enforce a right, you have violated legal spirit, and legal spirit is a necessary ingredient of rule of law, which is why the first matrix flowchart that we made is effectively the most important. And this makes me finish the ecosystem of what is called rule of law. Now, the final part of it, constitutionalism as we understand it to be. See, first things first, we figured out the relationship between rule of law and constitutionalism. Rule of law is to ensure that power originates from the law. Constitutionalism is limiting the power of the state. So when power originates from the law, which means the law will decide how much power you have. So the law is a limiting force on power. Constitutionalism also speaks of limiting power. Who has power? The state has power. And the state has 4 ingredients: got to have territory, got to be sovereign, there needs to be a functioning government, and there need to be people. If you have these 4, you can philosophically call yourself state, which is again a PYQ question asked before. Now, so constitutionalism is nothing but the idea of limited powers. Now, when I say constitutional government, this is also a PYQ, a government whose powers are restricted. So constitutional government means a government whose powers are restricted. So does that mean a constitutional court is a court whose powers are restricted? No. A constitutional court is a court which has the powers to pronounce the constitutionality of laws, whether the law is good or not. So the court is limiting the powers of the state by having the powers to review what the state does, which is basically pass laws. So when the constitutional court performs the function of judicial review, it is effectively performing or upholding the larger principle of constitutionalism, which is why the 2 constitutional courts in India are the Supreme Court and the High Courts of various states, because what they effectively do is pronounce upon the constitutionality of certain laws. This does not mean that the powers of the court are restricted. Of course, the courts also have the powers within the Constitution. The courts can only do what the Constitution allows them to do. So, for example, let us say the advice given by the Council of Ministers to the President cannot be inquired by a court of law. So yes, to that sense, you're also limiting the powers of the court. For example, let us say if something is in the 9th schedule and does not violate basic structure, the courts cannot review it. That's also limiting the powers of the court. For example, orders of the Delimitation Commission cannot be reviewed by a court. That's also limiting the powers of the court. But when the courts have the powers under 131 to do anything in the interest of natural justice, that is a constitutional court. when the courts have the powers under 32 and 226 to issue writs to enforce rights, that's also the function of a constitutional court. So a constitutional court effectively has a two-dimensional meaning. The more important meaning is that you could pronounce the constitutionality of laws. They've asked you this, they've asked you this, they haven't asked you this. It's only a matter of time the UPSC asks you this. And we've got to be a step ahead of the commission when it comes to the exam conducted by them. So constitutionalism effectively means limiting the powers of the state. Now, the best way to do this is we can't give any of the agencies of the state any such powers. We've got to do it by law. And therefore, rule of law also kicks in. And therefore, we have the concept of constitutional law. Constitutional law is any means through which you're limiting the powers of the state. So it could mean a law, it could mean a case law. For example, when the Constitutional Court gives a judgment which limits the powers of the state, let's say through the doctrine of basic structure, it is effectively undertaking constitutionalistic pursuits. Things like if you're appointing the governor, you have to speak to the chief minister. You're restricting, in a way, a power. If the no confidence motion has been passed, then the Council of Ministers must conventionally resign. It, of course, is a matter of convention. So, things like these, you're limiting the powers of the Council of Ministers because what you've effectively done is the fact that you have lost confidence of the House. Something very specifically in a law, that the Council of Ministers are collectively responsible to the lower house. That means you're limiting the powers of the Council of Ministers, which are an instrument of the state. So what you effectively are doing is constitutionalism, right? And therefore, constitutional law is everything that limits the powers of the state. And one of the ways to do this is through a law called the Constitution. It's a law, but it's a law that has a special meaning to it. Now, I'm going to tell you the purpose, I'm going to tell you the types, and then we're going to specifically focus on written constitutions. So bear with me, because we are a written constitution. Now, I've given you two purposes. One is a principal purpose, which is a constitution is any document which effectively gives you a structure to the government and the relationship between the government and the citizens. But as per our NCRTs, class 12th India's Constitution at Work, first chapter, there are four basic functions of the Constitution. One, it lays down the basic rules. Two, it decides who has the powers to make decisions. It tells you how the government should be constituted. Three, it also gives you limitations on the powers of the government. And fourth, it also enables the government to fulfill the aspirations of society. This is directly from your NCRTs. In case any of these options are in the options that are there in the prelims exam, you've got to mark them right, because the NCRTs are in fact the ultimate truth when it comes to the polity part of the exam, apart from the Constitution. Now, when we say the Constitution, it simply means a legal document. Now, it could be written or unwritten. A constitutional law is fairly similar to an unwritten constitution, in a way that any law which limits the state is constitutional law. So the basic difference between a written constitution and an unwritten constitution, very, very specifically, is a written constitution means there is one law that covers all of these four things. It does not mean it is the only law that covers all of the four things. It is that one law which covers all of these four. You could have a second law which will cover point 1. You'll have a third law which will cover point 4. You will have another law which will cover point 2 and 3. But there's a primary law, and this law therefore becomes superior to all other laws. Which is why we often say, for example, Article 13 Clause 2 says, as we were discussing earlier, no law can violate a fundamental right, which means fundamental rights are in the Constitution. So any law made by the union or the states, any ordinary law, therefore means that you cannot make any parliamentary or state law that violates something which is in the Constitution. And fundamental rights, by the virtue of being in the Constitution, get some special treatment. Similarly, you would have heard of things like constitutional bodies. The fact that they're in the Constitution allows them to get some special protections, like their salaries cannot be disturbed, their tenures cannot be diminished to their disadvantage, their expenditures and the salaries, etc., are to be charged to a consolidated fund of India, which means that they cannot be reduced. They aren't even voted whenever the budgets are passed. So therefore, you have certain advantages of having a primary law. It therefore creates what is effectively called sort of a supremacy of it all. It is also a very good way to uphold constitutionalism and effectively rule of law. An unwritten constitution means there are 4 different laws covering 4 different parts, covering 4 different areas. They're as important as each other, which means the legislature in an unwritten constitutional setup, let's say like the UK, would have equal powers to add, subtract, deduct, whatever you want to. But in a written constitution, because there is a single law, everything is written in one document primarily, you could restrict the powers of the parliament to make changes to it. And if you're making changes to the constitution, you would classify them as a separate set of changes called constituent powers. So the parliament has 2 kinds of powers. Constituent powers under 368 to amend the constitution, and ordinary powers under Schedule 7, Union List and Concurrent List to make ordinary laws on legislative subjects. So ordinary legislative powers and constituent legislative powers are very different things. You can only make that difference because there is a written constitution, right? This is one way to do this. This is on the basis of what is called codification. The second way that you could do this is on the basis of the level of government that you have. If you have a single government, then it's a unitary constitution. If you have more than one, you have 2 layers of government, it's a federal constitution. And power can never be distributed equally. So therefore, either center will have more powers than the states, or states will have more powers than the center. And it is exactly in this scenario that in a federal constitutional setup, a written constitution makes more sense. Because if there's one single law bigger than everything else, which can tell you this is what the center can do, this is what the states can do, it just makes it easier and therefore more hierarchical. If it was an unwritten constitution, that means the parliament, which is the center, could effectively give itself more powers than the states, and you could ridiculously not do anything about it. So therefore, there are some inherent advantages that India has by being a written constitution, and they are: you ensure there is no parliamentary supremacy. Even the parliament's powers to amend the constitution are restricted through 368. You've been able to come up with something called the doctrine of basic structure. For a federal setup like India, a written constitution makes so much sense because you can clearly allocate powers through a higher hierarchical law. It also ensures that there is better judicial review. If you think about it, in a constitutional setup which has a written constitution, you very clearly can allocate powers to the court to judicially review. And these powers that are given to the courts to judicially review cannot be taken down by the parliament, because the parliament is also subservient or subordinate to the written constitution. And because it is a higher document, it's a supreme law, sort of, the parliament can also not fluctuate your rights. So it's better for rights protections. And because you are giving the structure of government in a higher document, so separation of L, E and J, and them keeping a check on each other indirectly through different ways, can also be done through this written constitution. Remember, neither judicial review, nor federalism, nor separation of powers, nor checks and balances are anyways explicitly mentioned in the constitution. So this means if your question says, according to the Constitution, separation of powers is keeping the branches of state separate, it would be a wrong statement, because according to the Constitution means explicitly according to the Constitution. And this takes care of your primary advantages of what is called a written constitution. And just to cover the loop in just one line and nothing else, because if at all there has to be a question, it has to be very simply based. They've never asked doctrines because doctrines can be fairly vague and ambiguous. There are 6 basic doctrines that we've got to know at all times. What are they in one line? You've got the doctrine of basic structure, which means certain principles of the Constitution, certain ideas of the Constitution cannot be amended. They are defined by the Supreme Court on a case-to-case basis. It applies to both constitutional amendments and ordinary laws. So neither constitutional amendments nor ordinary laws can violate the basic structure. When we speak about harmonious construction is balancing conflicting provisions. It has 2 applications. The first, of course, is, let's say, balancing fundamental rights and directive principles. This very specifically means you can have a uniform civil code, but make sure it doesn't violate freedom of religion. And second is to balance center-state powers. For example, something is in the concurrent list, which means both the union and the states can make laws on something which is in the concurrent list. So how do you make sure such a conflict is resolved? Severability means a law has, let's say, 5 sections and only section 3 is problematic as violative of a fundamental right. You can specifically declare section 3 as invalid. Remember, when the court declares something is invalid, it simply makes it unoperational. The court cannot delete anything from the law. The doctrine of eclipse means simply this, that if there is a law that is being enforced in India, but the law was enacted before 1950, let's say for example the Indian Police Act, because the Penal Code no longer exists, of 1861, which allows for restrictions on movement. It's also applicable in 2024. You have a particular problem with the section of 1861 Police Act or the Police Act as a whole. It will not be void from 1861 because we don't have the authority to invalidate the effect of the laws before 1950. It is only applicable even if it's a pre-independence law and you're declaring it as invalid. Its effect could only be declared invalid post 1950. They are not void ab initio. Whereas if there is a law which has been passed after 1950, you can declare it void from the start. Colorable legislation simply means what can't be done directly should also not be done indirectly. For example, ordinances. Well, ordinances are structured in such a way that you should not bypass the legislature. So if you try to withdraw the ordinance before the session, or if you try to repromulgate it in a way that you're bypassing the legislature, you're taking away the inherent purpose of an ordinance. You're defeating the larger purpose of parliamentary democracy. What can't be done directly should also not be done indirectly. And lastly, reasonable classification, which is nothing what we've discussed before. It's a combination of intelligible differentia and rational nexus. So it simply means that for you to discriminate or to classify something, the basis should be reasonable, the objective should be fair, and by creating that classification, you're able to reach that objective. The chances of this to come in the pre are less, but just in case, to keep our bases covered, I've given you 6 extremely important doctrines that are applicable in so many different ways. Thank you. This is lecture number 2. See you for lecture number 3, legal history. And you've never done legal history like this before. Thank you for watching. Thank you for being a part of this. See you for lecture number 3. Bye-bye. few things. The first is you must understand the broad sort of milestones in our journey. Our journey effectively starts in the year 1600. And what happens in 1600 is the entry of the East India Company, the English East India Company. Now, this is generally done through a charter. A charter is directly sanctioned by the Crown of England, by the monarch of England. Now, when the company comes to India, it has been authorized by England to effectively run its operations and govern its subjects in India. Now, the company not only sees trade, but also finds ample opportunity to fraudulently and illegitimately diverse into the administration and the governance and taking over the control of affairs of the units which were a part of India at that time. But our first milestone happens to be when the Crown has authorized the company to enter India. Now, what slowly tends to happen is the company diversifies, enhances its reach, expands, and starts doing more things, which is not just about a trading company. It effectively also tends to become a pseudo or a semi-governing authority, which is why in 1757, through the Battle of Plassey, what you generally understand is that the company has formally acquired certain revenue collection rights. And revenue collection rights are a very important instrument of a governing authority. So basically, what is happening is the company as a trading unit is now becoming a trading and a governing authority. And that is effectively cemented in 1757 through the Battle of Plassey. Post that, because power corrupts and absolute power corrupts absolutely, the company tends to become a little too mighty. While one can say that the revolt of 1857 was a triggering factor, but it was not the primary factor for this. But what happens in November 1858 is that the company becomes strongly more subject to the Crown, to the British government, to the British ecosystem. So up until 1858, the company was functioning with a very high degree of autonomy. That autonomy was, of course, granted to the company through certain charters, through certain provisions. But that autonomy is going to be restricted. The British government is going to export their governmental structure and bring some order into the chaos that the company is tending to cause. And thereafter, what you see is an evolution of the British governmental administrative system in India. And also, simultaneously, we want to become independent. So these two forces are going to collide with each other, and eventually, on 15th August 1947, India will become an independent dominion. Yes, you heard that right. India becomes an independent dominion on 15th of August 1947. This means India was functionally independent, was free to do whatever it had to, but it had to still formally recognize England as its head of state. It had to formally recognize the Queen as its ultimate authority, even if it is ceremoniously, even if it is figuratively. But till on 15th August 1947, what we effectively become is an independent dominion of England. And once our constitution is up and running, has fully commenced, and every provision of the constitution is fully applicable to the territory of India, we become what is called a sovereign republic, which means we are again fully independent. And the difference this time is that we are a republic, which means our head of state, even ceremoniously, is not going to be the British monarch. It is going to be someone who we are going to elect, which is called the president. Now, these are your broad 5 milestones in the structural journey of India. These milestones will see a lot of events happening. You will see several factors influencing it. India would have witnessed the partition. India would have witnessed nationalist movements. India would have witnessed different forms of nationalist movements. And they're, of course, going to have an impact. But there's also another very important layer. While India is evolving, and that's because of how the British are making India evolve, the British are also evolving themselves. The British are turning from a full monarchy to a parliamentary monarchy as time passes by. So, as and when this happens more and more, the Parliament of England tends to become even more the more democratically representative institution. The ministers of England tend to have a larger role. So, the evolution of Britain from parliament, from a full monarchy to a parliamentary monarchy is obviously going to have an impact on the way the structures in India are also going to eventually pan out. So this entire ecosystem, as you'd like to call, effectively has 4 primary ingredients. So till about 1858, there are going to be laws which are going to give structure, power, autonomy, some functions to the company. I'd like to call them company laws. They're generally charters. Then post 1858, you will see proper British parliamentary acts governing a complete system of administration. In India, you'll generally see them to be called as the Indian Councils Act, the Government of India Acts, and so on and so forth. These are the 2 primary legal documents which had legal enforceability in India, illegitimately so, which have shaped India. So for the prelims exam, these 2 documents bear significant importance. Having said that, between the 2, it is actually the crown laws part of it which is more important for polity, and the company laws part of it, the regulating acts and so on and so forth, would therefore be slightly more important for modern history. Apart from this, you would also see several documents which are written as a cause of our freedom movement. You will see them right from 1895, something called the Swaraj Bill, to a publication called the Revolutionary by the Hindustan Socialist Republican Association, to several documents written by Sapru, by B.N. Rao, and so on and so forth. Now, these aspirational documents, of course, would have some hint to the kind of India they want to build, but they would have more significance on the kind of rights, the kind of privileges, the kind of benefits, the kind of society that India should create. So therefore, they would generally be discussed, adopted and integrated through the Constituent Assembly, because at least in the more recent times, the authors of these aspirational documents would effectively end up also becoming members of the Constituent Assembly. And lastly, we'll also see some international inspirations. Now, these inspirations could be in 2 ways. For instance, the idea of something taken from a country and a specific provision taken from somewhere else. So, for example, the idea of fundamental rights has been taken from the US Constitution, whereas more specifically, the phrase procedure established by law has been taken by the Japanese Constitution. And if you've watched the second lecture, we've had a detailed discussion on the differences between the 2 and how they're very important constitutional theories, if I may say so. Now, having said that, again, these inspirations that have come to us internationally have never been asked in the prelims exam, at least in the last 10 years. When you do specific sections, for example, when I do directive principles, I'll give you a quick comparative inspiration that, oh, we've taken it from the Irish Constitution, and the Irish Constitution has in fact taken it from, let's say, the Spanish Constitution. But that is for another time. What we are to be absolutely focused on, and with the highest amount of priority, are in fact what are called crown laws. And what is it that we are eventually coming to? We are eventually coming to creating what is called the Constitution of India Act, and that is going to be done by the Constituent Assembly, who's been mandated to draft and to pass a constitution for India. The Constitution of India, as you would know, we've discussed this in the second lecture, has certain functions. In fact, I've given you two sets of purposes to the Constitution of India. To any constitution, in fact, one of them is, of course, the general powers and responsibilities, and I've given you the NCRT version of it. But generally speaking, the Constitution of India 1950 would effectively be looking at the structure of the state, the powers and limitations of the state, and the rights and responsibilities of the state, the citizens, and the interaction between the two. So this is the larger context that I think we should generally begin our lecture on. And now we should take a magnifying glass and get a little more deeper into this evolution, which is essentially a bunch of milestones. So, to begin with, who are the primary people involved? Because we are effectively a colony till about 1947, there are four sets of entities which are going to shape our governance and administrative structures. At the helm of affairs is going to be the crown or the monarch. Now, over a period of time, the crown or the monarch is going to lose their individual power. They're going to be bound by the Council of Ministers, as it happened as an outcome of the Glorious Revolution in England in 1688, if I'm not wrong. But the crown plays a significant role because it is the crown who issues a charter to the English East India Company to effectively come to India as the sole English trading company to go expand into foreign territories of India as viewed by the British. Over a period of time, you will see the British Parliament becoming stronger and stronger. So they will eventually end up making certain laws for us. For example, the Indian Independence Act, the very act that gives us independence, transfers powers from the British Crown to the Constituent Assembly. That legal transfer of power, because power, like matter, cannot be created or destroyed, it can only be transferred. It is effectively a British parliamentary law, and that in fact is also a point of critique, but not particularly important for the prelims exam. Thirdly, because there is a parliament and they also follow a parliamentary system, more specifically a Westminster system, called Westminster because the place where the parliament is, the area is called Westminster, the building is called Westminster, which is also why the system is called the Westminster system. Now, the basic essence of it is that if you are a parliamentary democracy, then there is going to be an elected house, and then there are going to be ministers from that house, and the ministers are going to be collectively responsible to the house. That's the general understanding of parliamentary democracy. So it is effectively the ministers who would have executive power, and the ministers would, of course, would want certain policies to be made, because for them a colony like India is also a source of revenue generation, as they would view it in their minds. And lastly, you would of course have the grand old company, which is headquartered in London. So the directors of the company are going to play a role in manifesting the kind of powers that the company would effectively have. Now, these four stakeholders, as we understand it to be, are not necessarily exclusive. In fact, there are going to be certain cooperations, and there are also going to be certain conflicts as and when the case might be. So, for instance, you would often see that allegations were made that the company was a little too close to the crown, and the ministers are going to have a little bit of a tiff, or a little bit of a disagreement with the crown because of the kind of powers the crown was giving to the company, and the parliament would have a larger idea about what should be the future of India. In fact, this is one of the reasons why, even after Lord Irwin's declaration that India would be given a dominion status, and India never became a dominion of England. What India became was an independent dominion in 1947. India never became a dependent dominion, though we wanted to become a dominion because Lord Irwin had also agreed to this. But what had effectively happened was that even after Lord Irwin's declaration, there was severe resentment and disappointment amongst the Britishers, which was reflected in the British Parliament, which is why Lord Irwin had to take back his words, and which caused us extreme disappointment, which led us to effectively shun all moderate negotiations with the British, and completely be focused on the idea of Poon Swaraj, which was done through the Poon Swaraj Declaration, adopted in 1929 but made public in 1930. That, of course, your modern history teachers would effectively have taken care of, or your modern history books would address to it. But the stakeholders would effectively have some role to play in what is called the evolution of India. Now, we're going to look at two kinds of evolutions. On the first page, the kind of evolution that we're looking at is the political evolution, which simply means that as a political unit, as a unit of state, how has India evolved? So when the company came to India, we were basically a bunch of princely states. Now the company starts expanding, started claiming itself to be the ruler of these states, or to be the ruler of some of these. The company defeats a few. For example, that's what happened in 1757 when the company defeated Nawab Siraj-ud-Daulah. And therefore gained Diwani rights. I'll discuss this. So then what happens is, some of these areas are now under company rule, and you have some princely states. So collectively they become what are called British administered territories and princely states. And this continues to be the case till about we become independent. And just around that time, we are not just India, we are effectively undivided India. So it included India and current Bangladesh and Pakistan. Bangladesh back in the day was also called East Pakistan, and they were liberated in 1971. Now, we become undivided India with princely states. This is around the same time that the partition happens, and then we become what is called divided India, or we become independent India. The princely states become a part of India, and therefore what we have is called Union of India. So the British administered territories effectively become what is called independent India, and princely states are merged and consolidated and integrated, and what we effectively have is what is called Union of India. So this is what is called the political evolution of what is India today. And now we must look at the governance or the administrative evolution of what is India today. And that's the interesting part. So when we look at institutional evolution, we understand that there are three branches of state: the legislature and the executive, and of course the judiciary. Now, changes that happen to the legislature would effectively be reflected in the executive, and changes that happen to the executive would effectively be reflected in the legislature. So therefore, the changes that happened to the legislature and the executive must be done simultaneously, while the changes that happen to the judiciary could be looked at as a separate development. But the idea is that you've come to India as a company, and now you're growing your presence in India. Now, when you're growing your presence as a trading entity to a full-fledged governing authority, you'll have to put some systems in place. So what we have today in India as center and state and head of state and head of state at the center, and then you have and you have the governor, you have the president, you have the prime minister, the council of ministers, the chief minister, the council of ministers. All that is effectively an evolution of what this is. All that is a byproduct of whatever it is. So if we talk about the modern day India, where you've got the president, you've got the Lok Sabha, Rajya Sabha, you've got the Council of Ministers, which is headed by the Prime Minister, you've got the Supreme Court. This is essentially the India of today. You'll have something similar at the level of the states, where you've got the governor and you have state legislative assemblies and so on and so forth. All of this goes back to this. So the general understanding is, what is it that these Britishers are going to do to us? Who are the people who are going to do what they're going to do to us? So in the prelims exam, you will generally see questions on the basis of this. You will see questions on institutional changes, institutional landmarks, as opposed to political landmarks, as opposed to controversial landmarks, and so on and so forth. So you generally see that they'll set up something at a central level, then they'll set up something at the state level, because first they will only have one unit and then they'll have sub-units. So that evolution is effectively what I've tried to sort of show to you here. Now, for example, you'll first start with a governor, then you will have governor general, and because this is a single person, the single person would be assisted by an executive council. Now, of course, you will see that the governor or the governor general will tend to not listen to the executive council. So they will want to control the powers of the governor by making sure the person listens to the executive council. But the governor would still have, or the governor general would still have, the last say or the final say. So what will happen is, at the union level, this will remain something constant for some time. And then you'll create an additional level. You'll create a sub-unit, you'll create a sub-national level, in a manner of speaking, of course. So you'll have a governor and an executive council. So when your territory becomes too big, you divide it into sub-units so that it's easier to manage. It is more accountable, it's more efficient. It is again still what is called a very handheld British-centric setup. So you'll have a governor general and an executive council, and at the states level also, at the regional level also, you'll have a governor and an executive council. Now, you still are making all the powers. The executive has the legislative powers. There are no functional differences because you are a colony. And if you want to sustain the colony, you'll have to have some amount of separation between your lawmakers and people who are implementing the law. What you'll do is, you'll then create a legislative council. Now, you'll have a governor general, an executive council, and a legislative council. You'll do this for some time, and then you'll replicate a similar system when your regional units have become huge, when there is enough resentment from us that we want representation. So when we want to be important, when we want our voices to be heard, what they would effectively do is, they'll start giving us voices here, because they still want to control the larger colony of India. So this is the larger unit, these are your sub-units. So what effectively happens is, you have an executive council, and then you will have a provincial legislative council after some time. You'll first have just governor and executive council, then you'll have governor, executive council, and a parallel fully functional system, a provincial legislative assembly and ministers. So this means there are going to be two centers of power. Of course, these guys are going to have more power because they're colonizers, but we will also have some powers that are ours, that we decide. Of course, because we are still a colony, the governor would have the final say, the governor general would have the final say. But the concept of having two sources of power, two parallel governments, two parallel law-making institutions, two parallel political administrative units, it is called diarchy, which of course we will study in a lot of detail when we look at one of the provisions that made us do this. Now, you would want to then take it a step more. You would still want to keep your integrity as of the colony of India intact. And then you will realize, if I want to keep Indians happy, I'll have to get rid of British influence at the regional level. So what you'll try to do is create what we have today here. So we will not be nationally independent and nationally democratic, but regionally we will have all powers to us. So we'll have a legislative assembly and we'll have ministers. Of course, the governor would be far more powerful, will have the final say, will be able to outrank us, which is not the case today, because the governor today here does not get to do what the governor back in the day would. But this concept of having a fully functional, with all powers to us, is called full responsible government, right? Now, after this, there is nothing left. You've got to leave India. So therefore, what will happen is you will transfer powers to the Governor General and real powers to the Constituent Assembly to create a primary law called the Constitution. Very ironical that England themselves have a written constitution, a single written constitution, but they are more than happy to give powers to one singular body who will then make a written constitution for the very colony that they've colonized for more than 200 years, and they themselves don't have a single written constitution. So this becomes our independence checkpoint. And from here, when we become independent, we of course have the President, the Lok Sabha, the Rajya Sabha, and the Council of Ministers. And then till about 1956, we've got the President and the Lieutenant Governors, they call Raj Pramukhs and so on and so forth. And we basically have Part A, B, C, D states. Part A states happen to be British provinces. Part B happens to be princely states. Part C happens to be some special areas like Delhi, etc. And Part D at that time only contained one state called Andaman. And then in 1956, we completely reform this. We completely reorganize it. At the center, everything remains the same. From Part A, B, C, D, we become states and union territories. We've got governors for states and lieutenant governors for union territories. And all states and some union territories will have a legislative assembly and council of ministers. And a few states will also have a second chamber. So this is basically our institutional evolution. But legal history is still about here. And this is just the legislative and the executive front for it. Till about 1858, you will see the word Governor General. And then post 1858, you will see the word Viceroy. You can use them interchangeably. They're effectively people at the helm, the in charge of colony of India, which is why post 1858 is also called the vice-regal age, right? But you can use either of the two, it's completely fine. They effectively mean the same thing. Now comes the important part. If you want to be legitimate, you'll have to be, even if you're a colony, you'll have to be more accountable. You'll have to give more representation to us. And when you do that, you'll also have to give us more powers. But the British, being British, this will never be that simple. It will never be as easy as it looks. There will always be more than what meets the eye, which is why when they're going to be more accountable, that means they will want us to keep a check on them. You'll generally see the Governor General or the Governor taking the final shot. They'll be the ones who will overrule most decisions. They're the ones who would not be bound by what our legislative councils or assemblies are trying to say. Bear in mind, legislative council is a term that we use sort of nationally, and legislative assemblies is what we use regionally. And when they want to give us more representation, there's always going to be terms and conditions to it. Who can contest, who can vote, how many times, how will their vote be counted, What is it that they can make laws on? What is it that we can decide for ourselves? What is it that we will actually have powers on? It's always going to be a big question mark. And when they say that they're going to give us more powers, it's going to be basically hollow. And let me give you three simple examples of how all of this is actually true. For example, through the course of all of this, you will hear of something called limited franchise. What India has today is called a universal adult franchise. Franchise effectively means the ability to vote. Now, what we have is a universal adult franchise. Adult means anybody who's more than 18 years of age. So, universal means anyone in India who's more than 18 years of age is entitled to vote. Of course, that is also subject to certain conditions. For example, prisoners cannot vote. But generally, under normal circumstances, everyone above the age of 18 in India is effectively entitled to vote. Now, that wasn't the case. If you didn't have property, you were not allowed to vote. If you were not educated, you were not allowed to vote. There were several restrictions on voting itself. In fact, when people were to be elected to certain councils or assemblies, you had to be of a certain stature. You had to have some amount of economic wealth. In fact, a lot of times people who didn't have land could not vote. Now, these technical details are not going to be asked, but the fact that we've had limited voting till we became independent, till the very end, still stands to be true. Even the Government of India Act of 1935, which was supposed to give us a very close feel of what it feels like to be self-sufficient, they had limited voting rights given to us. Secondly, you'll also hear of something called separate electorates and joint electorates. So electorates is nothing but a constituency in some form. Electorate is generally a larger term, but it could be understood in the context of a constituency also. So you represent a constituency and therefore you are a part of a legislature. Now the constituency has two components. One, the voters, and two, the person who's contesting. So what happens in a separate electorate is that, for instance, you say there's a separate electorate for Muslims. Now this would mean that only the Muslims are going to vote, and this also means that the contestant will necessarily be a Muslim. That's what is called a separate electorate. Now a joint electorate means that anybody can vote, but the person who's contesting has to have a specific criteria. For example, a joint electorate for women and depressed classes. We have the same even today. We have reservation for scheduled castes and scheduled tribes in our MP, MLA constituencies. With the new Women Reservation Bill, we also now have joint electorates for women. So what does this mean? It means in a constituency reserved for scheduled castes, the person contesting has to necessarily be a scheduled caste. But anybody, whether they're a scheduled caste or not, can vote in that election. So that is what is called a joint electorate. The joint electorate system continues today. We have joint electorates for scheduled castes, scheduled tribes, now soon to be implemented, women as well. So there is a lot of terms and conditions that happen. Legislature and the executive tend to be your two primary organs of the state. But one must not forget that there's also something called the judiciary. Now, what generally happens here is when the company comes to govern its subjects, they would have their own company courts. The company courts are going to be for company subjects. Now, who is a company subject would also be a matter of concern, would be a matter of dispute, would be a matter of grave problem. Then what will happen is, over a period of time, you will see that proper crown courts are established, especially when the crown takes over after 1858. So we originally start with high courts, then we have Supreme Court and high courts at the same time. Then we cancel out Supreme Courts, we only have high courts. Then by 1935, we have the Federal Court of India and the high courts. And throughout all of this, we have what is called Privy Council. So the Privy Council, in one way, is the highest court in England for all of England's colonies. So let's say England has about 100 colonies. Ultimately, all cases on appeal would finally come to the Privy Council if they were allowed to come to the Privy Council, if the cases had merit to be heard by the Privy Council. The Privy Council is basically a very, very high court, a very, very supreme court in England for the colonies of England. Now, there haven't been any questions from here, but the general principle remains the same as far as our prelims is concerned. All through this is effectively the evolution done through certain sets of laws. Now, let's start with each of these. Let's understand what they are. And we have to do them in the slightest amount of detail, because please remember, unlike preamble, rights, directive principles, this is a low yield value topic. So the more crisp it is, the shorter it is, the more compact it is, the easier it is for you. So we start with 1600. Now, what is 1600 known for? 1600 is known for the entry of the East English India Company. Now, of course, the date was the 31st of December 1600, and Queen Elizabeth at that time had basically granted a charter to a company of London merchants to trade with East India. Now, a charter is nothing but a permanent which is to be given to a group. Now, this charter gives the company judicial powers, it gives the company executive powers. In fact, it also gives criminal powers, but it is only for company subjects. But the company subjects itself is a very, very abstract term. Are you a company subject if you're a British national? Or are you a company subject who is in any way working for the company? And at that time, you would generally see there are empires in India, there are kingdoms in India. And these kingdoms and empires are going to have their own legal systems, their own justice system. So there is going to be a lot of local conflict at some given point of time. But basically, what happens is this is the start of the imperial legal culture. The company slowly expands, the company slowly starts even deciding on cases with respect to non-company subjects as well. And not only are local triggered, the kingdoms triggered, even back home, for them back home in Britain, the parliament is irked, the council of ministers are therefore going to be irked. So what effectively happens is that by about 1726, the British Parliament, and this is after the Glorious Revolution, is extremely disappointed and flustered about how much of abusive or how expensive and how exploitative the company has become. Now, by no means they meant well for India. What meant was that they were unhappy with how the company was enjoying far too much freedom without any checks and balances whatsoever. So the Charter Act of 1726 wanted to sort of curb the powers of the company. So back in the day, company courts decisions were finished and ended there. But now on appeal go to the Privy Council and so on and so forth. Company appointed governors were also then given very, very defined legislative powers, and the company was not able to digest this, and therefore the company eventually started again transgressing these powers. There were enough cases registered, but what you need to just know is that 1726 was effectively to control and regulate the powers of East India Company while giving them legislative, executive and judicial powers. And that's when the turning point happens in 1757, the Battle of Plassey, which is why a very famous textbook in India is called From Plassey to Partition. So what effectively happens is the company, which is led by none other than Robert Clive, had defeated Nawab Siraj-ud-Daulah of Bengal, and this was the first major disruption to how things were to status quo. So what happens is when you defeat Sirajuddaulah, you effectively gain certain revenue rights, certain land rights, certain tangible ownership of a certain amount of territory. And therefore, the Diwani rights of Bengal, Bihar, and Orissa were granted to the company. While they were still the Nawab was basically nominal. The Nawab was basically just there for the dignity and the respect of it. But real powers were, of course, held by the East India Company. So, the East India Company now becomes a very, very large landed power. Now, again, with great power comes great abuse. Unfortunately, in their case, it never came with great responsibility. So therefore, what ends up happening is the company starts abusing its powers. The company starts taking things for granted. The company starts transgressing their jurisdictional limits, and that is why they are effectively sort of faced with another regulating act called the Regulating Act of 1773. Now, several changes have been made to this act. They're not important for the prelims exam. I'll give you some reference to this. But the Regulating Act of 1773 wanted to further control and give more structural reforms to the organization and the affairs of the company. So, therefore, the kind of autonomy that the company was enjoying had to be reduced, and the British Parliament could have greater supervision over the affairs of the company. That was one of the primary effects, one of the primary outcomes of the Government of India Act of 1773. Now, the Governor General was having a blast all this while. So, they effectively sent 4 people to aid and advise the Governor General. The Governor General could still reject their advice through certain amendments that were made later on, 1784, etc., etc. But the 4 Executive Council members were supposed to be the restraining force on the very expansive powers held by the Governor General. By now, you had 3 major territories expanded under you. You had Calcutta, you had Bombay, and Madras. And when there are 3 equals, there's always going to be a question, who is more equal than the other? So what they did was they placed Calcutta at a higher pedestal, and Madras and Bombay became sort of number 2 to the Calcutta presidencies. And in a way, Calcutta becomes the national capital for Britain at a time when there was no nation whatsoever. But nonetheless, and to reaffirm what they really wanted to do, they set up what was called a Supreme Court back in the day in Calcutta in 1773. This was to be very closely modeled, and therefore you had kept a 5-year term for all of these guys, but it eventually was meaningless because the Governor General was still trying to override the advice of the Executive Council. Now, why was this case? It's because there were subsequent acts which were passed in 1781, in 1784. There were charters of 1813, charters of 1833. There was an amendment that was made to the 1773 Act in 1793. And all of this had very substantially diluted whatever you want to do with 1773. So the acts of 1781 and 84, the charters of 1813 and 1833, they're not important for the prelims exam. This is just to give you some form of context. And the amendment that was made to 1773 in 1993. Now, the idea was that because there was so much parliamentary discontentment in England, they really wanted to secure parliamentary control. And the parliament wanted to have greater say in what everybody was doing. Therefore, in 1781, they exempted the Governor General from the Supreme Court. In an amendment that was made in 1793, the Governor General could override the advice of the Executive Council on such extraordinary cases. And because Calcutta was seemingly superior, a Supreme Court was set up in Bombay in 1823. and there was a lot of tussle between if there's a Supreme Court in Calcutta and there's a Supreme Court in Bombay, who's the bigger one, or are we all equal? So there were a lot of organizational challenges. And then finally, in 1858, the Queen of England at that time, Queen Victoria, had issued a proclamation, and she became what was called the Empress of India. And therefore, what this basically means is that Indian territories which were under company rule now become directly under the Queen's rule. Now, this also means the Queen is the monarch, so they become under the direct control of Council of Ministers of England and the British Parliament. And this is actually where our story starts, because this is actually where our life tends to be greatly affected because of now institutional changes that are going to be made. So we first start with what is called the Indian Councils Act of 1861. Now, we've already done the broad structure before. So what does the Indian Councils Act of 1861 do? It effectively restructures the Governor General and the Governor General's Executive Council. Now, this is happening pan-India or pan-British India, by making sure that you are now going to create a sort of separation of powers between the Executive Council and the Legislative Council. Now, this effectively means there is a legislature. Now, this legislature is going to have British and Indians to it. But of course, the Indians would have a negligible role to play. The British would effectively have a larger role to play. But this was a functional division. This was not only for separation of powers, but this was also to create some form of limits to the office of the Governor General and also the Executive Council. But at the same time, you didn't want the legislature to also get too carried away, because forget not, you are still a colony, which means you would require the assent of the Governor General on practically any matter, no matter what. And all laws would require a compulsory sanction of it. In some cases, you would also require something called prior sanction. And both of these concepts are still absolutely existent today. Now, because Bombay and Madras were fighting for their legitimacy, Bombay and Madras also get independent legislative powers. So the governors of Bombay and Madras would effectively also have some territorial jurisdiction to make some kind of laws. And because the Supreme Court thing had created a lot of confusion, they abolished all the Supreme Courts, and you had a Supreme Court of Bombay, a High Court of Bombay, a High Court of Madras, and a High Court of Calcutta. Now, it is also actually for the first time where emergency powers are actually given to the governor of what were called British administered provinces or British administered territories. So this is their first substantive act on an institutional change that has happened to us. Now, immediately after this, you will see that in 1909, we passed what is called the Indian Councils Act. Now, the Indian Councils Act of 1909 is also called the Modelamento reforms because of the reforms, the suggestions that were made by Morley and Minto. Now, there are of course four very, very important things. Now, the reason is that it is in this context that there is obviously a little bit of resentment, and they wanted to counter it by providing for the first time some form of elections. Now, here when members were to be appointed to the Legislative Council, there were no elections. Now you would have elections. Elections where? To both central and state legislative councils. You started creating legislative councils at the level of the state. If you see this carefully, here you will have legislative councils here, and you will also have legislative councils here. So these are your state legislative councils. You will have elections here, you will have elections here, basically giving some form of representation, some form of democratic mandate in a certain kind. So this becomes very, very important. This becomes an extremely hallmark of a step. Now, this was good. Of course, the elections were fairly limited. There were too many terms and conditions. But yes, you would have elections to central and state legislative councils. There were excessive limitations on how you could vote. There were excessive limitations on who could contest. But at the same time, you were creating a multi-layered British ecosystem. And that's the point. You have a Governor General for India. You have presidencies and provinces. Presidencies tend to have more British power. Provinces tend to have less British power. Both are British governed. And of course, you have princely states which are complete the picture. The idea is you have now started to give executive council to your provinces as well. Otherwise, you just had the governor, and the governor was enjoying as the single person in charge of taking care of everything. So you're now creating multiple layers. This is exactly what we had discussed before. So you have a governor, and then after some time, the governor also has an executive. So you're simply evolving your ecosystem. Now, this is also the sign of something terrible that's going to happen, and this is going to cause a major rift in the way the leaderships were working at that time. Separate electorates for Muslims at the level of the states, not at the center, which means when we talk about the legislative council with the governor general, there is no separate electorates. It's only and only for the states. Now, the separate electorates, as I've explained to you, this means the voters are only going to be Muslims, and the person who's going to contest is only going to be a Muslim. This electorate is nothing but indicative of what is called the divide and rule policy that the British have been rather infamous for. Apart from this, as I've also told you, there is going to be an issue where you start creating a new office, both at the center and the states, called the Office of the Vice President. So these become your primary objectives or features of the Government of India Act of 1909 or the Indian Councils Act of 1909. The reason it's called the Indian Councils Act is because you are seeing more changes to the councils. You're seeing elections happening to the central and the state councils. You are also seeing separate electorates for Muslims, which is again happening at councils. You're giving limited voting and limited contesting rights, which is again happening at councils. So therefore, a large part of what this act is trying to do is reform your legislative chambers. And it's not a very well-intended reform, but a reform nonetheless. Now, then we have what is called the Government of India Act of 1990. Now, if there's one thing you should Government of India Act 1919 for, is the diarchy that was again to be given at the level of the provinces or the states, because at a national level you would not want to lose any form of control. So whatever representation you would want to give, or more powers you would want to give, you would want to give them at a provincial level. So what is basically a diarchy? A diarchy is, there's nothing happening at the central level. You've got the Governor General, you've got the Executive Council, you've got the Legislative Council. Now you have elections to the Legislative Council also, but at the level of provinces, you've got the Executive Council. You used to have a state legislative council. Now you have a provincial legislative assembly, and from here you're going to have proper ministers. So you have effectively created some form of a mini parliamentary system, but at the level of the states, because it's closer to people, it's more intimate, and therefore these ministers are going to be collectively responsible to the respective assemblies. Now this means we anyways have X things on which the center can make laws on, Y things that on which the state can make laws on, Z things on which both the center and the states can make laws on. The problem is with Y. Now there are two state power making bodies within the state. So what is going to happen is you're going to keep a separate list of things on which they are going to have powers, and they are the ones giving us power. So they've reserved some things for themselves, and they would some powers to us, law and executive making power. But as we know, all of this would effectively be hollow. And the more crucial, the more difficult, the more sensitive power would again be left with the reserved list, which is effectively with the governor and the executive general. If I also remember correctly, the Government of India Act of 1919 was also fairly snottish in their own way, in the sense that they said that this will not be applicable to civilizationally backward areas, which the British thought was civilizationally backward. So almost Assam, Orissa, the entire Chota Nagpur Plateau region, they were all to be exempted from even having a shot at very, very limited and very, very conditional democracy. However, this was something that was promised to us. This was something that was to be delivered to us, and Congress had, of course, rejected the act, said it was indiscriminately, and they would still fight the election nonetheless. There was a review that was to happen of this act after 10 years in 1929, which modern history would remember with something. So basically what is happening now is that at the level of the states, we've got two power centers. One is the British center and one is the Indian center. The Indian center, of course, is extremely limited, extremely concise, and extremely, you could say, insufficient, for the lack of a better word. And then finally, what you have is the Government of India Act of 1935, the last piece of legislation. Now, what is very interesting about it is that it wanted to do something, but only half of it was effectively done. Now, the Government of India Act wanted to create what is called an All India Federation. So it, for the first time, wanted to give us the idea of India by merging princely states into British provinces, which is why on several occasions, for example, when you read territorial provisions, and more importantly, when you read citizenship provisions in the Constitution, you will find a reference to India defined as per the Government of India Act of 1935. This is what is called undivided India, as we would know it to be. Now, what they wanted to create was an all India federation, which effectively meant that you would have provinces and princely states become a part of a larger political unit. Now, how would you do this? What you had done for states in 1919, you want to do for the center in 1935. So you wanted to create two centers of power for the center. So they wanted to create, there was of course the Governor General, there would be the Executive Council. This is one power center, and this would become basically Government of India Act 1919, but for the center, but at a national level. So instead of one legislature, they would want to have two, largely because you're representing such a large geographical area, and you would have ministers chosen from here who would be collectively responsible. Now, they said that there should be two houses, Council of States and Federal Assembly. Now, the members would come from provinces and the princely states. The provinces would have direct elections to this Council of States, and the princely states, because they're effectively kingdoms, they are monarchies, they would nominate people and send them across. As far as the Federal Assembly is concerned, and federal means anything which has two layers, so they would have indirect elections in the provinces. So we would have the already elected members of the provincial assemblies, therefore people to be sent to what is called the Federal Assembly, and then the princely states would effectively just be sending nominated members here. Now, all of this does not happen. It is all an idea. It is rejected because the states did not agree. Now, the princely states did not agree because this was effectively accession to India, it was effectively becoming a part of India, but it would come at a cost. There are rarely free lunches in life. So this effectively means that they would have to surrender their territory, and that would come a surrendering of a lot of autonomy for a certain fraction of seats, and they were not okay with it. For them to get a certain fraction of seats, they would have to surrender almost half their territory to British, and they were not okay with this largely. The technical details are not important. As a result, it didn't fall through. So therefore, the previously existing ecosystem of 1919 for the center, this continued. So this was what was the case. So effectively, after 1935, what was previously happening since 1919 for the center continued, and this diarchy never happened. So basically, you had exactly what was happening up until now. You had a Governor General, Executive Council, and Legislative Council, and what you did remarkably was have full responsible government at the provinces level, which means your Executive Council was gone. You had provincial legislative assemblies, and ministers would be chosen from them, and they would effectively be responsible to them. So you had basically democracy, except for the fact that the governor was an outsider. The governor was British appointed. The governor, of course, at that time would have far more powers than what the governors do have today, but nonetheless, this was the closest we came to parliamentary democracy during the British Raj. Now, if there is a center and the states, there has to be a power sharing mechanism. Like how we have the 7th schedule today, the union list, the state list, and the concurrent list, what we had was a federal list and a provincial list. Now, obviously, if all powers are with one, so there is no allocation of no allocation of powers. So therefore, you would have one set of powers completely given to provincial legislatures. But at the federal level, what you would now have is a reserved list and a transferred list. This is exactly what was happening. So you would have a few things on which they would have complete powers, and on a few things they would have complete powers. So this was originally proposed. Now the idea is, because the All India Federation did not go through, and listen to this carefully, because the All India Federation did not go through, this also did not go through, because ultimately the Legislative Council was in great favor of the British. There was no diarchy anymore. So this was proposed. This also didn't happen because this didn't happen. And of course, if there are two lists and there are things that are mentioned in either of the lists, you've allocated them. But what if there is something that is not mentioned in either? And this was a prelims question. So residuary power would effectively be with the Governor General. You will not give it here because it would effectively be ineffective because you're a colony. You would want to keep it centralized, and this is the closest you can be to keep it centralized. So this was a PYQ question, which is nothing but residuary powers were with the Governor General. So this is the Government of India Act 1935. Now, apart from this, you expanded electorates which were separate in nature. Not only were Muslims, but also now several other religions also getting separate electorates. You had extended separate electorates to a very large number simply because they wanted to advance what was called their divide and rule policy. So therefore, what they ended up doing was they gave more separate electorates to Christians, they gave separate electorates to Sikhs, and so on and so forth. And joint electorates not only for depressed classes but also for women. The Federal Court of India, which is today now the Supreme Court, was established in 1935. The Reserve Bank of India was also established because the Government of India Act had provision for it. So the RBI Act was passed later. And of course, emergency powers were more strengthened. So the Government of India Act 1935 has had a fair amount of role to play. But in the prelims, you'll generally see a question from here. These things are not generally asked, and when you come to subject-specific topics, I'll give a reference there and then. For example, the Government of India Act also contains something called Instruments of Accession, which is also a reference point for directive principles. So this is the last act passed by the British to strengthen or to establish their order. And then finally, the Indian Independence Act of 1947 gets passed. Clement Attlee is the Prime Minister of Britain at this time. And the Cabinet Mission just a year before had already provisioned for the Constituent Assembly. So what the Indian Independence Act does is it transfers power to the Constituent Assembly from the British Crown. So therefore, the Constituent Assembly becomes the legitimate mandate holder for India. And the Constituent Assembly had a primary job to draft the Constitution for us. So therefore, when the Indian Independence Act is passed, we are still an independent dominion, because the head of state is still formally the queen or the monarch. But after the constitution comes into force in 1950, that's when we become a sovereign republic. In fact, as a symbolic act, the very last article of our constitution actually repeals the Indian Independence Act, essentially trying to convey a message that the British are no one to give us independence, as they were no one to govern us in the first place, rightfully so. Now, as far as the prelims is concerned, you've got to know two things about the Constituent Assembly. One is the composition and the other is the structure. Now, there is no need to do the mathematical composition of the Constituent Assembly. What you effectively need to know is that we are going to be creating India, and India as per Government of India Act, which is effectively British provinces and princely states. And the Constituent Assembly is going to be evolving in its structure. You're going to have a pre-partition Constituent Assembly and you're going to have a post-partition Constituent Assembly. So of course the post-partition Constituent Assembly will have lesser seats. So the Constituent Assembly is supposed to have provinces and princely states, representations from British provinces and princely states. Now the British provinces are to be, the members of the British provinces to the Constituent Assembly are to be indirectly elected by members of the provincial legislative assemblies, which means existing MLAs will elect members to the Constituent Assembly, very much like how the Rajya Sabha gets elected. The only difference is each Constituent Assembly will have three parts: Muslims, Sikhs, and whatever is left, general. So all Muslim members of a specific legislative assembly will choose Muslims, all Sikh members will choose Sikh, and everybody else will choose general. And there is going to be a number defined in proportion to their population. Now this, being the nature of it, may not be asked, but this much is important, has been asked very recently. And members representing princely states will not be on an election basis but on a selection basis, and this has to be done on consultation with the kings or the queens of the princely states, and this is honestly more than enough as far as composition is concerned. Now when we look at the structure, so the structure is again fairly simple. What we are looking at is, this is nothing but a sort of a parliament, but a very special parliament whose job is to create what is called the Constitution of India. Now, at the very helm of affairs, you have B.N. Rao, who's an advisor to the Constituent Assembly. That's number one. Number two, the role played by B.N. Rao is extremely important in terms of him introducing ideas and advising everybody else working in a certain manner. So if the parliament today has parliamentary committees, they would have a certain set of committees. The most important of it, because your primary job is to draft the constitution, is the drafting committee. The drafting committee is headed by B.R. Ambedkar, In UPSC, they generally don't ask member names. In state services, of course, they do. But the chairperson of the drafting committee is nobody else than Dr. Bhim Rao Ambedkar, who's obviously done a splendid job in the way things are running and in the way the constitution has been drafted. Now, the drafting committee is supported by four extremely important committees. These are the four ones which are important. You have a committee on fundamental rights, minorities, tribals, and excluded areas. And their job is to give suggestions or ideas on provisions regarding rights, minorities, tribals, and excluded areas to be included in the Constitution. So you will have a lot of to and fro, back and forth between the drafting committee and this committee. Similarly, you'll have a committee on provinces. You'll have a committee on chief commissioners, provinces or chief commissioner areas, which are effectively union territories, and a committee on rules and procedure. Each of these committees are headed by four extremely important people. The Rights, Minorities, Tribal Areas Committee is headed by Shri Yr. You will have the Provinces Committee headed by Vallabhbhai Patel. You will have the Chief Commissioners Committee headed by Patabi Sitramaiah, who will play a very important role in the second second Provincial Linguistics Committee set up for state reorganization. And third is Dr. Rajendra Prasad, who heads the Rules and Procedures Committee. Now, in certain cases, so for example, if the chair is Sri Allada Swami Iyer, you will have separate people heading fundamental rights, minorities, and tribals. So, for example, the person heading a subcommittee on fundamental rights under the larger committee, J.B. Kriplani. Apart from Kriplani Sahab heading fundamental rights subcommittee, you will also see, for example, H.C. Mukherjee, who would be heading the committee on minorities, and so on and so forth. So the idea is that this is the organizational framework. The analysis of the Constituent Assembly is never asked. So please don't get into whether it was truly representative or not. Was it good enough or not? Of course, most members of the Constituent Assembly were from the Indian National Congress. That's because after 1937 gave full democratic setups at the regional level. Provincial elections were held in 1937 and therefore the Congress had effectively won almost a majority of seats in almost all places. So yes, most members would come from there. Similarly, you would also see that there were enough, there were women members, not enough. There were also Dalit members also, there were also members from other religions, but this is the larger idea. The first Lok Sabha elections happened in 1952, which means from 1946 till about 1950, you are the Constituent Assembly. From 1950 to 1952, you are a very limited Constituent Assembly / interim parliament. And then, of course, from 1952 onwards, you have the first Lok Sabha and the first set of elections in the country. But this is effectively what is India's legal history. Let's not go in any more detail than this. If there has to be a question in the prelims exam, it would sufficiently be handled from here itself. So that is that. And on that note, I'll end this lecture and I'll see you for territory and citizenship in lecture number 4 on Monday, which is effectively tomorrow. Thank you for watching. Bye bye.